We are live, Mr. Chairman.
Great. Good afternoon. It is 3:43 on the 9th of March, 2022. This is a hearing of the House Judiciary Committee. We're going to get right into it with House Bill 529. Delegate Pena Melnick, who's the Vice Chair of Health and Government Operations, cannot be with us right now because she is presiding now over Health and Government Operations. So we're going to go ahead with her bill, though. And her staff, just to emphasize, this is a staff member, Michelle Furman, is going to testify on her behalf, along with Kenneth Capone, Rachel London, Matthew Rice, Catherine Mello. So if we could have them brought into the room, please. We'll give the sponsors representative 3 minutes, and then we'll hear from the rest of the panel. So if Ms. Furman was available, there she is. All right. So again, committee, just sort of a rules of the road thing. Obviously, Ms. Furman is here standing in because we've got the vice chair of HGO does have a pressing engagement. You can direct questions to her, but keep in mind that she's not the delegate. So please, be nice. So now that we've thoroughly intimidated Ms. Furman, I will let her have 3 minutes.
Thank you for having me, Chairman Clippinger, Vice Chair Moon, and members of the Judiciary Committee. My name is Michelle Furman, and I am pleased to present House Bill 529, Supported Decision Making, on behalf of Delegate Pena Melnick, who is currently chairing an HGO. 1 in 5 people in Maryland are living with a disability. Some of these individuals may struggle with making big decisions about their life in multiple areas, including medical care, relationships, and finance. Individuals living with a disability are often able to make these decisions with support from friends, relatives, and other trusted people. This bill allows a person with a disability to voluntarily enter into a supported decision-making agreement to assist in making, communicating, and executing life decisions. While individuals may need assistance in the decision-making process, they do not always need a guardian to make those decisions for them. Supported decision-making is an accepted and successful alternative. Guardianship can strip these individuals of their hard-earned independence and offend their sense of dignity. Simply put, this is a human rights issue. This bill would preserve the rights of a whole population of Marylanders by allowing those living with a disability the opportunity to make their own decisions, promoting self-determination, control, and autonomy. This accommodation is not new or novel. 19 states have passed laws allowing for supported decision-making, including Texas, DC, and Delaware. All residents of our great state deserve the opportunity to be in the driver's seat of their own life. Supported decision-making provides an accommodation for the decision-making process while preserving basic human rights. We have accepted amendments to conform with the cross-filed Senate bill that recently passed through the Senate unanimously. Our supporters, stakeholders, and advocates who you'll hear from today have worked tirelessly to present this amended bill to the House, garnering a huge amount of support, including from the judiciary, whose testimony was emailed to you earlier today. Language was added to the Health General section at the end of the bill in order to ensure that, similarly to the way people cannot be deemed incapable of making decisions solely because of communicating by ways other than speech, they can also not be deemed incapable of making decisions solely because they are using a supported decision-making agreement. Thank you for the opportunity to present House Bill 529. I respectfully request a favorable report.
All right. Mr. Capone, I believe I see you there. Mr. Capone, are you there? Ken Capone. Ken Capone. There he is. Mr. Capone, would you please testify for 2 minutes?
Hello, committee members. My name is Ken Capone. I am the director of People on the Go of Maryland, which is Maryland's statewide self-advocacy organization. We are here to testify in support of HB 529, Estates and Trusts, supported decision-making. Supported decision-making is a tool that allows people with disabilities to retain their decision-making capacity by choosing supporters to help them make choices instead of the alternative of having someone appointed as a certain substitute decision-maker. With the introduction of supported decision-making, people with disabilities have the opportunity to do really what people without disabilities have done when it comes to having input in life choices. If you think about it, if you don't have a disability, you still are using supported decision-making. We all ask our friends, family, and others how we should handle certain choices in a given situation. In a sense, the policy of supported decision-making helps level the playing field between those with disabilities and those without, because this policy presumes competence and that anybody is capable of making choices for them. They just might want and need some support. A person using supported decision-making chooses trusted advisors, such as friends, family members, or professionals, to serve as supporters. The supporters agree to support the person with a disability to understand, consider, and communicate decisions. This gives the person with a disability the tools to make his or her own informed decisions. With supported decision-making, I was able to get advice, information, and communicate decisions with supporters, and retained my ability to make my own decisions on important issues like purchasing a house, trust and estate documents for my deceased mother, and purchasing a modified van. With supported decision-making, you supporters do not make decisions for you like a certain substitute decision-maker may decide if appointed to do so. We feel supported decision-making is important for people with disabilities and their families as an alternative to guardianship. This method of assistance allows for people with disabilities to have the input from their family and other key supporters recognized without taking away the person's legal rights to make the decisions. Historically, we have not presumed competence when it comes to people with disabilities being able to make appropriate life choices. Some examples include the area of finance and managing one's own money, choosing where and with whom to live, and even whether or not you can refuse or accept medical treatment. Some families have turned to guardianship to make some of these life decisions for their loved ones, even though guardianship was not necessary. In conclusion, supported decision-making give options for those seeking to retain independence with supports and the dignity of presuming competence. We ask for a favorable report.
Thank you very much, Mr. Capone. We'll hear now from Rachel London, please. Rachel London for 2 minutes.
Great. Thank you, Mr. Chair. I'm Rachel London. I'm the Executive Director of the Maryland Developmental Disabilities Council. We're a statewide public policy organization that creates change to make it possible for people with developmental disabilities to live the lives they want with the support they need. I'm also the chair of the Developmental Disabilities Coalition. We are 5 statewide organizations committed to improving opportunities and outcomes for people with intellectual and developmental disabilities in Maryland. You've heard how supported decision-making increases self-determination, choice, and control. What it also does do is it allows people to make their own decisions. It does not allow the supporters that they choose to use have any authority over those decisions. You've also heard that a lot of work was done to get to where we are today. The council has always supported decision-making, and we started many years ago with funding to bring a group of 27 organizations, advocacy groups, the judiciary, people with disabilities and family members together to get to where we are. And then since then have worked very, very closely with all of the stakeholders so that we have a bill with the amendments that you also have from the Senate side that we have all agreed on. That being said, I think there's clearly a lot of education that will continue to be needed, not just for people with disabilities, not just for other people who may use supported decision-making, but for all of the partners, including the hospitals, including other healthcare providers. I want to say today that we, the council, is committed to continue to offer that help and that funding to bring all of those partners together to develop the educational resources, the trainings, whatever is needed to ensure that this is implemented in the way that it is intended, that everybody understands what supported decision-making is, and what the limitations and restrictions are. And just as a final note, I just want to, another point of clarity. In order to use supported decision-making, a person has to be competent. So if a person has a substitute decision maker that's derived from the incapacity of that person to make decisions, then the authority stays intact. The authority of that substitute decision maker stays intact. I know that that's come up. So again, obviously a lot of education will be needed, and the council will continue to support that both in advocacy and funding. Thank you.
Thank you. Matthew Rice, please, for 2 minutes. All right, not here. We'll go to Catherine Mello for 2 minutes, perhaps.
Hello, good afternoon. My name is Catherine Reinhardt Mello, representing the Brain Injury Association of Maryland. Our organization provides education, advocacy, and partners with research entities to address the needs of Marylanders living with brain injury. We're also part of Maryland's No Wrong Door system, providing information and assistance to callers throughout the state and connecting them with resources. Brain injury can impact physical, cognitive, and emotional functioning. And after a person sustains a brain injury, many recover in a matter of days or weeks. But for those with more severe injuries, the impact may be lifelong. There's a lot of uncertainty about the trajectory that someone's recovery may take and when they may regain some or all of their decision-making capacity. Creating supported decision-making agreements as the person regains capacity allows for gradual transition of decision-making responsibilities from a substitute decision maker back to the person without imposing guardianship. In our experience, once guardianship is in place, it's difficult to terminate, as you'll read in Teresa Banner's testimony. We've encountered several situations that highlight the need to put supported decision-making at the forefront for individuals and families when they're considering their options after a person sustains a severe brain injury. We've worked with people with clear discrepancies between their priorities and their guardian's priorities. Several situations, the person wanted to live in their own housing with supports, and the guardian decided that they should live in a group home. We've also seen some overreach from guardians and powers of attorney trying to make day-to-day decisions for people, like whether they should be able to have dessert or whether they can smoke. Passing House Bill 529 would be a great step toward recognizing the rights of a person with a disability to govern their own lives and focusing on what they can do to make decisions with supports as a default assumption rather than an exception. Increasing the use of supported decision-making agreements during recovery from brain injury would set expectations early that decision-making responsibility should stay with the person as much as possible, and supporters can help them with gathering information and considering potential impact versus making decisions for the person. Please give a favorable report to House Bill 529.
Thank you very much. Thank you very much. We're gonna, I think there are several people who are on the second panel who are here, so I'm just gonna keep going forward here and then we'll take some questions. Margot Quinlan, I think I saw on here, there she is. Margot Quinlan for 2 minutes, please.
Great. Thank you, Chair, Vice Chair, members of the committee. My name is Margot Quinlan with the Mental Health Association of Maryland. We're here in support of House Bill 529. And I really want to talk a little bit about the intersection of older adults with mental health challenges and how this bill would support that community in particular. And I think folks know we're really in the midst of an unprecedented elder boom. Our 60 and older population here in Maryland is expected to grow by over 300,000 in the next decade. Our state's 85 and older population will increase by over 150% in the next 25 years. About 42% of Maryland veterans are over 65 years old. And it's projected that by 2045, older people of color will comprise half of all older adults over age 65. Our older adult population is the fastest growing population of people with behavioral health concerns, including cognitive and mental health challenges, substance use, and lasting impacts of isolation, loneliness, and depression due to the pandemic. This bill really has the opportunity to address these unique needs of Maryland's older adult population, and in turn really protect the dignity and autonomy of our communities by centering the capacity for choice, care, and appropriate community supports, as you've already kind of heard. I want to talk really quickly too. Our public guardianship program, which is mentioned, currently guides the care of hundreds of vulnerable older adults, many with dementia, with mental illnesses, with substance use disorders. And individuals with behavioral health disorders represent a disproportionate number of those in the program, and they tend to be in the program for many years. And so we really see supported decision-making as a tool to prioritize people's ability to make decisions with appropriate supports and to serve as an intervention to public guardianship, which again, just protects the autonomy, protects the independence, and relies on the well-being of our communities for our older adult population. So for all of these reasons, we would support a favorable report on House Bill 529. Thank you.
Megan Rusciano, please.
Chair and honorable members of the committee, my name is Megan Rusciano. I'm a managing attorney at Disability Rights Maryland, and we strongly support this bill. The concept of supported decision-making may seem new to you, but you just need to know three things. The first is that it's a reasonable accommodation. Second, it does not replace any existing legal tools. And third, it's a well-established best practice. This bill does something that's very simple. It recognizes that some people need accommodations to communicate their decisions. Think about a supporter as an interpreter, somebody who helps convey information in a way that a person can understand so that they can make their own decisions. It's a reasonable accommodation under the Americans with Disabilities Act. And really, to take issue with this bill is to take issue with federal law that people with disabilities get the support that they need to access services. You might ask then, why do we need this bill? Because people with disabilities continue to have their decisions ignored, and we can't litigate every single case. That's why we need this bill. It formally recognizes supported decision-making, and it will immediately change the lives of people with disabilities as evidence in the testimony before you. This bill doesn't replace existing legal tools, it works in conjunction with them. So as the judiciary notes in their favorable testimony, guardianship is still a tool in the toolbox. This is just a less restrictive alternative we need to consider beforehand. This bill also doesn't replace powers of attorney. A supporter cannot make decisions for a person like an agent can. And this bill, as amended with input from the Estates and Trust section, makes that very clear. Finally, if you're uncertain about supported decision-making, know that it really has been well vetted. This bill is the result of years of thoughtful discourse and collaboration, and nothing in this bill has not been enacted or introduced in other states. Over 20 states have passed legislation on this, and more pass legislation each year. The American Bar Association endorsed it in 2017, as has the Uniform Law Commission, the U.S. Department of Education, the U.S. Department of Health and Human Services, and others. Supported decision-making isn't an idea that's going to go away. It's our reality. And we here in Maryland are a bit behind the times. This is no longer innovative. It is ultimately foundational. Maryland can either be a state that recognizes that people with disabilities should have the support that they need, or we can be a state that's comfortable allowing them to experience discrimination. I think that we are the former, and as such, I ask for a favorable report on this bill. Thank you.
Thank you very much. We're going to take questions right now, and then there's another group of about 5 people trying to balance it out a little bit here with people who've been able to stay with us today. So questions for this panel, Delegate Bartlett.
Thank you, Mr. Chair, and thank you all for being here. This is an excellent bill. I'm so sorry the sponsor couldn't be here, but this is excellent. I love the ability to maintain control over one's life, and this is just a supportive mechanism. Please, or life decisions. Let me know, I was looking in the bill, I wanted to find out, there's no requirement, I don't think, and maybe this is a question for Megan, I'm not sure, but there's no requirement that one needs to be declared with a disability in the sense of a government, because that gets denied and all that junk. You don't have to go through that process, right? This is just an agreement between 2 people who, and the state will recognize the agreement. Is that correct?
That is exactly correct. The idea is that it could be actually open to anyone, but there's no barrier to say you have to prove that you have this certain level of disability. It's available to any adult.
Yeah, it's great, because I will say that I have taken individuals with developmental disabilities, and the doctor is talking to me, drives me absolutely crazy when I'm not the patient. So great job, great bill. Thank you very much.
Delegate Cardin.
Thank you very much, Mr. Chair. Just very quickly, and I don't know who the appropriate person is, for 2 quick questions. First of all, has the State Bar and particularly, I guess, the appropriate sections, I think there'd be multiple sections, maybe the States and Trusts and elder care sections, have they looked into this and given their sign off, number one? Number two is, what if somebody files a petition to void this agreement and to require some sort of guardianship against the wishes of the individual? How is that handled?
Sure. So I will just say you'll be hearing shortly from Christine Hubbard from the Estates and Trust section of the bar. They helped us develop a number of amendments and came in as favorable, with amendments favoring making the bill similar to the Senate bill. The Elder and Disability Law section of the bar also submitted favorable testimony. So we have the support of those two sections. Per your second question, what ended up happening is somebody files a petition for guardianship and this agreement is pending. The court and the judiciary notes this in their testimony. The court would do an analysis of whether or not this is a viable, less restrictive alternative before imposing that guardianship. So what this bill does is, currently our law requires that folks consider less restrictive alternatives like powers of attorney, advanced medical directives before pursuing guardianship. This bill would require supported decision-making as another one of those that has to be considered.
I have a question, and I've gone through the bill once, but maybe I think I've missed it. Is there anything that restricts a person who is there, who is designated as a supported decision maker from entering into financial agreements? Or, do they get paid? Can they encumber? It doesn't appear that they would encumber the person with financial obligations, but I guess I'm kind of wondering about that. Maybe I'm just misreading it or misunderstanding it, but if you could help me out with whether they can encumber somebody with some financial obligations, I'd appreciate it.
They wouldn't be, encumbering anybody with a financial obligation. This is just a role of somebody who's, has a relationship of trust and confidence, provides support. The adult is still the decision maker. There is no, that is kind of the backbone of this bill. The adult remains the decision maker. This is just someone that provides information, advice, if asked, helps translate information. There's no, financial obligation contemplated in that relationship.
So I guess let me go a little further. So, if one of the examples that I believe I heard was that somebody could buy a house, somebody could buy a car. What if they were buying a house from the person who was the supporting decision maker? Is there any concern that there could be sort of a conflict of interest there? Are there any restrictions based on whether they could enter into a financial agreement or into any kind of contracting agreement?
So there wouldn't be, basically, this bill is centered on folks who are capable, as Rachel London indicated in her testimony. It's just folks who need additional support. So in this context, you would be able to designate, you're the decision maker, you'd be able to designate a supporter to help you. If the decision is buying a house and you're the person and your supporter is the person who's selling the house, the bill is explicit that you would have to address how you would deal with any conflict of interest that may arise from that relationship. So the idea is that because, I can buy a house from my parents, right? My parents might be my supporters. There's a potential conflict there. We could address that. But because my parents aren't making me buy the house or making the decision for me, that isn't as strong of a conflict. We thought that it just has to be named in the agreement how that would be addressed.
Okay, we'll go to further questions now. Delegate Jones, Rachel Jones, please.
Thank you, Mr. Chair. So for the record, if you could clarify for me, this is something that a person with a disability would opt into as a reasonable accommodation, is that correct?
That is correct, yes.
And what should happen if that person should decide they no longer want a supportive decision-making representative?
Sure. So there is a process within the bill regarding how to revoke the supported decision-making agreement. They could receive, could be something that's as simple as an oral revocation that's documented and is provided to the supporter.
Okay, so I just want to, again, for the record, say that, Disability Rights Maryland and the Disability, the DD Council and other organizations are supportive of voluntary opt-in accommodations for persons with disabilities. That's correct.
Yes, this is something that based on the person, the person has a right, if they want to say as an accommodation, I want this, that they have that option, and this is what that solidifies. So yes.
Thank you very much, Megan.
Thank you. Delegate Shetty, then Delegate Cardin with a second bite. Delegate Shetty.
Thank you, Mr. Chair. Sorry, Delegate Cardin. Thank you for this bill, and thank you, advocates, for your work on this. I think this is a wonderful issue, and I'm really glad to have an opportunity to hear from you directly on and from our earlier advocate who shared why this is important to him as well. I guess I think about this a little bit in the context, and this is perhaps a little bit outside of the scope of what you all had in mind, but my mother was recently diagnosed with dementia. She's sort of in the early stages still, where we're kind of in the power struggle stage. And, I think a supported decision-making might be appropriate for these earlier stages, but then pretty soon we could, and in theory, at any point with a dementia case, you could transition into a more more of like a guardianship or power of attorney exclusive right to decide on behalf of the individual situation. So I'm just wondering if this bill contemplates scenarios like this, where maybe the individual opts in for supported care, but then either needs to transition into more support, or like what happens if they need additional care? Is there like an automatic kick over to a POA or something to that effect?
It's a great question. So yes, the intent is to see this bill as an option that can be used. And we are very grateful to have the support of both the Alzheimer's Association and AARP on this. But the idea would be, supported decision-making would be available so long as a person has that ability and that capacity. But there's always a need for a power of attorney when somebody loses that ability. So that would transition to, you're no longer able to make your own decisions. You have a power of attorney who is making those decisions for you. So that is definitely contemplated.
Okay, thank you. And so just to clarify, I guess, because who and at what point does a POA kick in? Like who makes that assessment that it is now time for that to occur?
Sure. So, powers of attorney there's different types of powers of attorney. This spring power of attorney, or one that's durable. So you can have one that is active now. That power of attorney can always make decisions for you, but as long as a principal is competent, they can always make their own decisions. If there is a question about a person's capacity from a doctor, from a bank, from third parties, that's usually how this arises, when somebody says, I don't know if this person can make a decision anymore. Then the power would transition. But what this tries to do in giving the person that authority for as long as they can, it kind of emboldens people to have these conversations about when is it time. It might be time, sit down with mom and say, things are, we want to make sure that your wishes are respected, but we think that it's time to transition now to somebody making those decisions for you. So it is definitely something that's contemplated in the language.
Thank you. That's very helpful. Thank you, Mr. Chair.
Delegate Cardin.
Thank you, and thanks for the second bite of the apple, Mr. Chair. Just very quickly, because this is really great stuff, and it's great when we have nonpartisan stuff that we're really trying to work out, because it's good intention legislation. So ballots, and it's good. Delegate Shetty went first. It was perfect, because this is really related to my only other question, which is, so last year we passed the SAFE Act, which dealt with primarily with fiduciaries that are taking advantage of exploiting particularly older adults, but it could be used, I guess, for other individuals, perhaps with disabilities. And the question is, would these people be included in that? And if not, if they're given some, like as the chair asked, some fiduciary responsibilities or doing some things, and they are doing nefarious type, actions, we have a new cause of action now. Would they be able to be included in that? Number one. And number two is, if we're transitioning, but yet the person who's advising or helping or assisting is really not necessarily looking out for the best interest of the individual, of the adult who should be making these decisions while they're transitioning to a power of attorney, how can the court intercede, or how can somebody intercede to try and make sure that they're not getting exploited?
Sure. So the first question, there's a specific provision in the bill that prevents somebody who has been convicted of financial exploitation under the SAFE Act from ever being named a supporter in a supported decision-making agreement. In many ways, I think that Maryland is well poised to pass this supported decision-making law now that we have the SAFE Act as an additional protection for financial exploitation. As far as the second question of a supporter maybe engaging in some malfeasance, what happens there? I think that actually with the amendments that were brought in with the Estates and Trust section, there's a requirement that unless a person expressly objects, that copies be provided to any existing powers of attorney as a balance. So the idea is that this is about creating a series of relationships. People keep people safe. The more people you have eyes on a person, the more likely you are to be able to identify situations of abuse and respond to it. So the normal mechanisms that folks would use to report abuse still exist. Adult protective services, if they're in some sort of state services, Medicaid services, then the Office of Healthcare Equality, things, there are other options available to ensure that people are kept safe. But I think that this bill is well positioned now because of the protections that we have now in Maryland.
Further questions for this panel? Seeing none, we thank you all very, very much for all of your work on this and all of your testimony here. We're going to move to the second panel, which includes Allie Anderson, Gail Godwin, Christine Hubbard from the Estates and Trusts section of the bar, Jonathan Lastly, Brennan Lester, and Ellen Caligari. If I could begin, please, with Allie Anderson, please, for 2 minutes.
Good afternoon. Thank you for the opportunity to testify in support of House Bill 529. My name is Allie Andreessen, and I am the Long-Term Care Assistance Project staff attorney at Maryland Legal Aid. Maryland Legal Aid is a nonprofit law firm that provides free legal services to the state's low-income and vulnerable residents. Maryland Legal Aid frequently represents and advocates for older adults and people with disabilities in matters pertaining to access to care, Medicaid services in the community, and the individual rights of nursing home and assisted living facility residents. This bill creates the process to establish supported decision-making agreements in Maryland. If enacted, it will create clear guidelines and protections in these agreements, providing adults with disabilities the assistance and support needed to make, communicate, and effectuate decisions. Persons with disabilities and older adults must retain self-determination and the dignity that comes with maintaining control over their lives. Individual decision-making is a human right, and every adult has the right to make life choices and to have those choices respected. These life choices can be as simple as what they wear and as serious as how they spend their money and what medical treatments they receive. This bill codifies the understanding that adults have the right to make life choices. Supported decision-making provides a less restrictive statutory tool for older adults and people with disabilities, allowing them to retain their right to make personal decisions and effectuate those decisions, potentially preventing the need for a substitute decision maker, such as a guardian. Legal aid regularly represents people who are living with a disability and those with diminished capacity facing issues concerning decision-making. For example, recently, legal aid was contacted by a long-term care ombudsman about an assisted living facility resident living under a guardianship order. The resident's guardian refused to talk to the resident, the person living under the guardianship, and would move her from one facility to another every few months. This was extremely disruptive to the resident's life, and she could do nothing to stop it. She was subject to the will of the guardian and had no input in her core life decisions, including her living arrangements. With the assistance of the ombudsman, the resident was referred to the guardianship attorney for the circuit court to have her case reviewed by a magistrate. However, this entire proceeding may have been avoided if supported decision-making framework had been considered or integrated into her guardianship order.
Ms. Anderson, I need you to begin to wrap up, please.
Thank you. For the reasons stated above, legal aid supports House Bill 529, and we urge a favorable report. Thank you for the opportunity to speak.
Gail Godwin now, please, for 2 minutes. Gail Godwin. Gail Godwin is not here, so we'll move on to Christine Hubbard, please.
Good afternoon. My name is Christine Hubbard. I am the chair-elect of the Maryland State Bar Association Estate and Trust Law Section, testifying in favor of House Bill 529 with amendment. This bill authorizes the use of supported decision-making agreements, which is really designed to prevent or delay the appointment of a guardian for people who may be compromised, either mentally or physically, but still capable of making their own decisions. This allows for that important self-determination to the greatest extent possible. However, it also has key provisions within the bill that helps to prevent abuse by making the supporter accountable, and also helps to prevent conflicts between the supported decision-making agreement and the adult's powers of attorney and advance directives. There were issues with this bill when we first saw it. We worked closely with the coalition and the sponsors to amend the bill. And the bill, as amended by the sponsors in the Senate, now adopted in the House, addressed all of our concerns. Some of those key amendments include the requirement that this agreement be in writing and signed by the adult and the supporter. And the supporter is obligated to give a copy of this agreement to the agent under the power of attorney, agent under the advance directive, or the trustee under the revocable trust. It also makes it crystal clear that the supporter cannot make decisions for the adult. They cannot act on behalf of the adult. They cannot enforce the adult's decisions or effectuate transactions for the adult. Any ambiguity in that regard has been cleaned up. It also makes it very clear that this supported decision-making agreement cannot supersede or supplant the adult's power of attorney or advance directive. So as the bill now reads with amendment, we believe that it provides manageable, effective, supported decision-making agreements, and it also protects the interests of the adult. For these reasons, we ask for a favorable report on House Bill 529 with amendment.
Jonathan Lastly now for 2 minutes.
Thank you, Mr. Chair, members of the committee. I'm Jonathan Lastly on behalf of the Estate and Trust Law section of the Maryland State Bar Association. As Ms. Hubbard just reviewed, we've worked closely with the advocates for this bill to provide protections that really address the questions that both you, Mr. Chair, and Delegate Cardin raised earlier, to provide checks and balances on these arrangements. I mean, the way to think of disability is it's a continuum. Some people do wake up one day and poof, they're disabled, but most people it's a scale. And the idea is to keep people going independently for as long as possible. And what these arrangements do with the protections we've built in with the amendments is allow people to be in the room with somebody. They allow them to gather information on their behalf and present it to them so that they can indeed make their own decisions independently. So they don't supplant agency, they don't create an agency arrangement, they don't supplant guardianships or powers of attorney, but they in fact can work with those people. So if it's necessary, so say, for example, a person says, I want to buy a house. Well, they don't have the capacity to go out and sign all the documents. The supported decision maker can work to make sure that the power of attorney is brought into the room and help the supported person get those decisions implemented, but they themselves can't do it. So what does this look like for a third party? If somebody shows up with the decision maker, obviously the adult, the person who's actually making the decision, they're there, they can say, I want this person in the room with me. But let's say they can't get out and get to the bank and get information on their accounts or something. This agreement would give the supporter the ability to go and gather that information. Couldn't do anything with it, but they can gather it, take it back to the supported person, and work with them on that. As somebody pointed out earlier, these supporters would be subject to the SAFE Act, so there would not be any problem there. And I think with the work we've done, this makes for a really strong bill, and we urge a favorable report with the amendments that you have before you.
Brennan Lester. Brennan Lester.
I believe we have a couple people in the waiting room. Still,
All right.
Gail Godwin was in the waiting room. Thank you.
Gail Godwin's in the waiting room. All right, well, we'll go to Ellen Caligari, and then they'll bring in the other people who are in the waiting room. So let's hear from Ms. Caligari here for 2 minutes.
Thanks. I'm Ellen Caligari, and I'm personally and professionally really highly in support of this bill, and thank you for your time this afternoon. I have been an attorney for over 40 years, and I have worked hard to protect the most vulnerable in our community, children and adults with disabilities. And I have multiple family members with disabilities, and I've had the honor of acting as, their informal supporters over the years. I want to make 3 quick points. Number 1 is that this is really the standard internationally, best practice internationally and nationally. Supported decision-making promotes the autonomous decision-making of all adults. The second point is, we're talking about the coalition. So I've been involved with the coalition for several years. And one of the things so important about the supported decision-making coalition is that it had wide representation from Marylanders all over the state. And so much thought has gone into the drafting of this legislation over a number of years to bring us here today, which is so wonderful. The last point that I want to make is that I'm the co-editor of the Guardianship and its Alternatives Handbook, Maryland Handbook. And really what this gives us, this legislation, is just one more tool in the toolkit. So we have advanced healthcare directives, we have powers of attorney, we have guardianship, and if this legislation is enacted into law, we would have one more less restrictive alternative to guardianship. And I urge you, and it sounds like there's many people who are supportive of supported decision-making here, to give this a favorable report. Thank you so much for your time.
All right, let's see if we can get Gail Godwin in for 2 minutes, please. Gail Godwin. Gail Godwin. No Gail Godwin. Brennan Lester. All right, let's take questions for this panel, and if they show up, we'll go from there. Are there questions for this panel? All right, seeing none, we thank you all very much. And I believe that concludes the witness list for House Bill 529. We thank you all very much for speaking with us today. and we appreciate it. All right, let's go now to the next bill, which I have as House Bill 585. From Delegate Pat Young, please. If we go, and it will be just from him, so that's fine. So Delegate Young for 3 minutes.
Thank you, Mr. Chairman. For the record, Delegate Pat Young, Chair of the Baltimore County Delegation, and I'm happy to present to the Judiciary Committee HB 585, Baltimore County Ordinance Court Judges and Surviving Spouses Pensions. Essentially, I think it's pretty straightforward. This bill requires Baltimore County to pay a pension to specified retired judges of the Baltimore County Ordinance Court. The bill includes benefits for the surviving spouses of a deceased Ordinance Court retiree. And this bill has passed the delegation. We do have a cross file that I believe is passed out of committee. Honestly, what we were trying to do, and when this was brought up to us during the interim from our Ordinance Court judges, they're the only elected officials in Baltimore County that do not have a pension system. So other counties, some counties don't have an Ordinance Court judges. When this was established, they didn't have a pension system. Other counties have created pension systems for their Ordinance Court judges. So we're honestly modernizing and providing the same benefit that all other elected officials in the county have. And if I could, Mr. Chairman, a moment of personal privilege.
Go ahead.
Well, this is my 8th year in the legislature, and I believe that this is also my first and also last time presenting to the prestigious Judiciary Committee as a member of the House of Delegates. And I just wanted to say that, Mr. Chairman, under your leadership, this has been an amazing committee with such great work coming out of it, such a product. As I just am, it is a pleasure is all mine to be in front of you, sir. And I appreciate the opportunity to present this bill to you and to your members.
Is there a motion for an unfavorable?
Oh, sorry.
Oh, I'm sorry. Oh, that was supposed to be in my head. All right. Thank you very much. Delegate Cardin has some hard-hitting and insightful questions.
Just real quick, there was no opposition and the county is not opposed to this, correct?
That is correct.
Okay. And it passed unanimously out, right?
It did.
Okay. Well, those are all the witnesses, and Delegate Pat Young's visit to the pirate ship is now complete.
Thank you, Mr. Chairman.
Thank you very much. That concludes the testimony on House Bill 585. We're now moving, I believe, to House Bill 199. Yes, Delegate Adams' aide is here for the Dorchester County delegation. We're also going to hear from Chip McLeod from the Cambridge Waterfront Development Group. So we'll go ahead and hear from Delegate Adams' assistant, and then we'll go to Mr. McLeod. Okay, for 3 minutes. Go ahead.
Thank you, Mr. Chairman, and good afternoon, members of the committee and Chairman. Thank you for having me today to present the bill on behalf of Delegate Adams for the Dorchester County delegation. House Bill 199. This was brought at the request of the County Council of Dorchester County. In 2018, Cambridge Waterfront Development was established by the Cambridge City Council and the Dorchester County Council. House Bill 199 alters the Local Government Tort Claims Act to include Cambridge Waterfront Development under local government and will provide protections through the act similar to ones afforded to other economic development entities across the state. The bill applies prospectively only and may not be applied or interpreted to have any effect on or application to any cause of action arising before the bill's effective date. As Dorchester County and Cambridge continue to grow and redevelop, Cambridge Waterfront Development will continue to be an important partner. Thank you for the time, and we would ask for a favorable vote on this local bill.
Chip McLeod, please.
Yes, Mr. Chairman, members of the committee, my name is Chip McLeod. I'm an attorney on the Eastern Shore, and I serve as general counsel to Cambridge Waterfront Development, Inc. Cambridge Waterfront Development, Inc. is a creature of the city of Cambridge and Dorchester County. It is an economic development nonprofit corporation that was set up several years ago for the sole purpose of helping the city and the county redevelop the Cambridge waterfront. Any of you that have driven down Route 50 across the Choptank River Bridge and you've looked to the right and you've seen the University of Maryland Shore Health Hospital on that property on the right, that area has now been aggregated to about 35 acres of land that Cambridge Waterfront Development, Inc. is working on behalf of the city and the county to redevelop. The request and the purpose of this legislation is to qualify or get CWDI added to the list of entities in the Local Government Tort Claims Act for purposes of CWDI getting coverage ultimately from the Local Government Insurance Trust. And I know this committee is familiar with that, I believe, that arrangement, but right now, the property that Cambridge Waterfront Development, Inc. is responsible for and just took title to, most of it was in the city of Cambridge or owned by the city of Cambridge and was already covered through the city of Cambridge's participation in Legit. The other important, so CWDI is a creature of the local governments and doing the work of the local governments is looking for that treatment as an entity under the Local Government Tort Claims Act. The other important thing is about timing. The purpose of CWDI is to convert the property that it has and get it sold out to private developers and put on the tax rolls. This is not a scenario where CWDI is looking for this protection and it plans to own the property and be holding events and things like that. What's going to happen with the majority of this waterfront property is it's going to be turned over and sold off to developers to redevelop in the waterfront, saving for sure a promenade, a waterfront promenade around the property. So that is the purpose of the legislation, and I'd be happy to answer any questions, Mr. Chairman.
All right, we'll go to have questions now from Delegate Cox, please.
Thank you, Mr. Chair, and thank you, Mr. McLeod. It's good to see you all today. Real quick, I know you're heavily involved in the details of this, but some of us know a little bit about it, but not enough to really understand. Now, when you come across the bridge and you're looking over to the right, that property that you mentioned would be inclusive of what's commonly known as Salewinds or Governor's Hall at Salewinds. Is that right?
Correct. When you look to the right in Cambridge, half of what you see is about 15 or 16 acres was owned by University of Maryland for the hospital. Another same amount of acreage was owned by the city of Cambridge called the port property, or some people know it as where Governor's Hall is located. Both those parcels, the hospital property and the city port property, which incidentally used to be owned by the state of Maryland, was given by the state to the city to redevelop. Those are the two properties. So when you combine them both, you end up with about 35 acres. So, but really two major parcels there.
And I think it was, I'm trying to remember the governor. I saw a plaque when I was in Salewinds recently that indicated that the state of Maryland was giving it over for a venue because there's no real venue mid-shore for large gatherings and such. And is it the intent to redevelop that and tear that down and to, as well as with the hospital and to sell that, take that, those interests and hand it over to private business? Is that the intent?
Well, that Governor's Hall that most people know, that was Governor Schaefer's project. Thank Governor Schaefer for what he did for Cambridge and the Midshore area when he gave all that attention and helped establish Governor's Hall, because it's been a very popular venue. One of the conditions of the property going to CWDI is for CWDI to create a comparable meeting venue place. That building itself is in very rough shape, and it is going to be demolished when the hospital is demolished. That's the other thing for the committee to know. This project, the most important thing that CWDI has to do next is demolish the hospital. Before anything can be done on that waterfront property, that hospital has to come down, as does old Governor's Hall. And the whole idea will be that'll be replaced, and there will be another event, special event venue on the water or near the water for what the kind of events that were hosted by at Governor's Hall. And the idea is for community events to be held there. If you know Governor's Hall, there's a lot of local fundraising events that are held there, big ones. And the idea is the waterfront is going to be activated to encourage that in even a more spectacular way.
Under private development or under the town's control?
Under private development. The goal is for all this property to be sold or long-term leased to private developers to benefit the tax rolls or enhance the tax rolls and create jobs. CWD&I, it was not created to own and operate event venues or things like that. What it hopes to do is sell off as much of this waterfront property according to a plan. There's a plan, but save the deep wharf and save a promenade all the way around, bringing around a mile or more promenade that goes around this entire waterfront.
And last question, what will become of the long-term leaseholder that operates a restaurant there? Is there a plan, a buyout, or how's that going to work? As well as with the hospital, is there a plan to have a new hospital built in the locality?
Well, in the hospital, actually, Shore Health has already opened a new freestanding medical facility and really some spectacular state-of-the-art healthcare services in Cambridge. So part of a big plan for University of Maryland on the Eastern Shore was to phase out the old hospital and replace it with a freestanding medical facility. And that's all done, and it's really nice. So everybody's known for years this hospital. And by the way, this decommissioning of a hospital is very unique in Maryland. There aren't many cases of old hospitals being really decommissioned and then torn down. And this is about to happen in Cambridge. And, it's no small feat that actually this transfer of property occurred just actually in January, that property from the hospital to CWD&I. So, but as far as tenants, you mentioned lessees, there are no lessees on the property now that's under the control. There was somebody that was operating Governor's Hall on a short-term lease with the city. But that person has found another place to continue to do what they do, because everybody has known this day is coming, that Governor's Hall is going to come down, so we can begin looking for somebody to do something better.
Okay, thanks.
Vice Chair.
Thank you, Mr. Chair. I hate to be asking questions on a local bill like this, but I'm just looking at the 5301 of courts and judicial proceedings, where you're attempting to add this entity into this list of, I guess, what's called local government. And the only question I have is this. Some of the stuff in here is obvious. Local government is a charter county, a code county, Baltimore City, and then you get down through it and you start to get to some of Howard County Economic Development Authority. And I guess I would have thought I'd see more local entities of this nature in here, and I guess I'm trying to understand why it appears to only be Garrett, Carroll, and a couple other local entities in here, and why I don't see multitudes more of these. Is there something unique going on in Dorchester or say in Garrett that required the creation of this entity versus doing it through existing government entities, or is this function just covered by the government in other places?
Well, Mr. Vice Chair, I'd like to try to answer that. The reason you see these nonprofit economic development corporations set up by local governments, in my opinion, is they are trying to allow something to occur with probably less politics. When you get into economic development, and here in the city of Cambridge, you have 35 acres of prime waterfront property. There's a lot. And in fact, the city of Cambridge and Dorchester County have been talking about this waterfront for decades. There have been charrettes, there have been studies for 30 years over what to do with this waterfront. So in this case, and I'm very familiar because we represent the city, our firm actually serves as a city attorney for Cambridge. The reason the local officials in the county and the city decided to do it is they saw that over 30 years, not much was getting done. And they thought if there was a separate entity with a board member, with a board with expertise to do things like this, it may take a little bit of the politics out of pulling off a big project like this and actually infuse some expertise that maybe the local governments have. So by example, on the board of Cambridge Waterfront Development, Inc., it's a 7-member board. One of the members is the executive director of the Stadium Authority, Michael Friends, because the governor has an appointee on this 7-member board. So that gives you an idea of the level of expertise that was brought to this board to foster some state relationships. The other thing about the list you see in the statute, this is a little background. I happened to, at one point, I served as general counsel to the local government insurance trust, legit. And one of the things that people that know local government insurance trusts understand is, I mean, it's a pool for local governments, of course, but local governments can sponsor entities in for coverage. And often local government members of legit will say, hey, we have an economic development board, or we have this commission that we would also like to be covered. One of the requirements for coverage in legit is you have to be exempt or included in the Local Government Tort Claims Act. Because of course, local government legit.
Now you're getting to where
that would
I was
answer. I
going
know.
with this.
So, and because I know this, when I'm working with CWDI and they're saying, what about insurance? I said, well, you know, ideally you should be getting coverage through legit because you were created by the county and the city, right? You're very much like them, but you can't be with legit because you're not in the Local Government Tort Claims Act. But other entities like you are in the Local Government Tort Claims Act for this purpose. So why don't we see if we can get you in? That's why.
Yeah, that answers my question.
That's why we're
I was
trying to get in
wondering
that
if the
list to go
liability
legit.
limit was needed.
Yeah.
Okay. All right. Thank you.
Thank you.
Further questions for the panel? Seeing none, we thank you very much. We're going to go to the one witness in opposition, and that is Bruce Plaxton, please. Bruce Plaxton, please, for 2 minutes. He's going to be let in from the waiting room. He'll be sure to take off his YouTube link so there's no background noise, and just leave the Zoom link on. There is Mr. Plaxton, please. You take yourself off mute, Mr. Plaxton, for 2 minutes. Opposition. Mr. Plaxton, you've got to take the YouTube link down. He's going to be let in from the waiting room. He'll be sure to take off his YouTube link so there's no background noise. And just leave the Zoom link on. There is Mr. Plaxton, please.
Could you make sure that I don't have
Mr. Plaxton for 2 minutes?
Yeah, I'm going to get out of the Zoom. Sorry.
You don't want to get out of the Zoom. You just want to get out of the YouTube link.
I'm out of the YouTube link. Sorry, Mr. Chair. Thank you, Mr. Chair, Vice Chair, members of the committee. It's a pleasure to be in front of you. I just heard quite a bit of testimony of what can only be described as a private development. I wrote the words down: private development, private developers, several times. This is a 35-acre major development with entertainment venues, boat slips, mixed use housing and retail, and a lot of things that clearly are not governmental functions and not meant for immunity. What is lost in all of this testimony is that by bringing them into the Local Government Tort Claims Act, all of these projects will be capped, a hard cap, not a pain and suffering cap, but a hard cap of $400,000. So if there is a dock collapse, a building collapse, a major calamity in this 35-acre development, your constituents, your visitors to Cambridge will be limited to a $400,000 recovery. From my reading of the fiscal note, this is only to save what was described as a few $1,000s for the developers. What you heard is that the city is not going to even keep this property. They're going to take it. They're going to sell it to private developers who will make a profit. And the only people who are giving up their rights are the constituents and the people, the Marylanders, who will visit these private businesses and not be entitled to full recovery if they are injured in this private enterprise. You heard the proponents say this will be used for large gatherings, private developments, for profit. It will be the flagship of Cambridge. I'm looking at a map of what is going to be developed here in terms of future development. And quite frankly, to save a few $1,000s on insurance each year is coins in the cushions. And you're asking your constituents and the Marylanders to give up their rights to save some private developers a few dollars. I'm happy to answer any questions. This is bad any type of expansion of Governmental Tort Claims Act is bad public policy.
Other questions for Mr. Plaxton? Questions for Mr. Plaxton? Delegate McComas.
Mr. Plaxton, I have a question for you. Basically, if this is developed, okay, and then the folks buy the property or whatever, doesn't that break this issue because it's not going to be owned by the economic development? It's going to be owned by the developer at that point?
Yeah,
And
it's not clear to me what exactly is being sold and what's being maintained by the entity the Cambridge Development Economic Development Authority. Presumably they're going to maintain part of this development, and they would enjoy the $400,000 benefit. And I'm not certain how much of it they're going to run and how much private developers are going to run. And if they built some of these improvements, then yes, they would be a target defendant, and the people would not be able to recover. I'm not sure what happens. I'm not sure how to answer your question because I'm not sure what in a hybrid development like this, what happens, Delegate. I'm not trying to fudge or punt the question. I'm not quite sure who owns what.
Right. Well, I guess. Well, if you look at what their budget is now, it's like minuscule. And I think, I'm trying to think what a economic development group that's really just a promoter, not a buyer, just a promoter of getting business to locate there and develop properties and sell things. I would think that business doesn't want to be an instrument of the Economic Development Committee. And I think maybe, I don't know, I guess what I'm saying is we need more information, but you might be looking for ghosts that aren't there, because that's your job. I mean, you oppose all immunities and you oppose any expansion of the Local Tort Claims Act. So, we've been around together a lot on that kind of stuff. So I'm just thinking maybe there needs some clarification, and maybe the sponsor of the bill could provide that as to what their plans are. And then if you're so concerned, maybe they could put some language in the bill that says, it's for their cheerleading to get economic development and not be a participant in the economic development and an ownership.
What I heard is that they were actually going to build it, but maybe I heard that wrong. In other words, that they were going to develop the marina, the boat ramps, places like that, and then turn it over or sell it or lease it to private developments. And if there is a problem where there's a building collapse because something that this entity built, that would fall back on them.
Well, certainly if they're leasing it and they're the owner, yeah, I would agree with you. But I think the question is, we're not clear as to what their role is. That's, at least I'm not real clear on it.
Yeah, I mean, the fiscal note talks about $9,000 or $10,000 in insurance and saving them a couple of grand in insurance, and it seems like much ado about nothing.
Well, but if you're having come from local government, you really have to watch those pennies, and quite honestly, they may feel that they don't want to impose any more tax increases or other expenses for their population because they need to provide the basic services, police, streets, trash, that kind of stuff. So I'm just kind of wondering if we really have a good idea of what the issue is.
Yeah, I'm not sure cheerleading or economic development is what was envisioned when the Local Government Tort Claim Act was passed, when it was meant to protect against police, fire, and typical, governmental functions, to protect cities and municipalities from being sued for protect what you called the nuts and bolts or the normal governmental functions.
Well, I know our town has an economic development component and the Bel Air Business Alliance and things, and they do good work, but they're not building any buildings, and they're not selling land, and they're not, what I'm saying? They're just kind of cheerleaders and getting people together,
Yeah.
and that's
Yeah, tearing down a hospital and developing 35 acres feels like more than just cheerleading.
Well, they're lucky they have it, to be honest with you. I mean, they're very fortunate that they've got that amount of land to develop.
Are there further questions for Mr. Plaxton? All right, seeing none, we thank you very much. That concludes the testimony for House Bill 199. We thank you very much. We're going to go now to House Bill 1370 1270 from Delegate Hill. We'll hear from Delegate Hill, Byron McFarland, Timothy Chance. There is one person in opposition, so we'll hear from Delegate Hill for 3 minutes, please, and then Mr. McFarland and Mr. Chance. So Delegate Hill.
Thank you, Mr. Chairman, and good afternoon to Mr. Chairman and Vice Chair Moon and the rest of the Judiciary Committee members. For the record, I'm Terry Hill presenting House Bill 1270, which would create a statutory transfer on death deed for real property in order to avoid for at least some of our residents the potentially crippling time and cost of going through probate for the purposes of transferring a primary residence to an heir. The family home, as you all know, is often the most valuable asset that an individual owns. And we also know that the home sometimes has many generations or extended family members living in it. And when the homeowner dies, even family members who are to be heirs and are living in the home have to file through probate in order for the home to transfer. And there are a number of different instruments that are available, but most of them require hiring a lawyer and are still costly. So when we're talking about low and moderate income families, that cost may be prohibitive. And as a result, the families will often simply not go through the process, and the home is closed or sold for tax sale. And this has resulted in many cases in housing insecurity for the folks who are living in the home. It can also lead to put people at risk of homelessness, and frankly, it destabilizes neighborhoods. And a house that's sold for a tax sale doesn't retain anywhere near the value of a house where people can continue living in it and paying the taxes and all of those other kinds of things. So this bill actually arose out of the Attorney General's COVID-19 Access to Justice Task Force. It was one of 4 bills that the Life and Health Planning Subcommittee offered last year. One of those bills was enacted, 2 others came out of the House but did not get out of the Senate and are reintroduced this year. But what we recognized when it came to this entity, the transfer of death deed for real property, is that the various sections of the law of the bar, the elder law section, the estates and trusts, and the real property section, have been in discussion with this for some time. And despite the fact that there is a uniform real property transfer on death deed that has been available for some years, and that there are at least 29 states and the District of Columbia and Virgin Islands who have a transfer on death deed for real property, this was becoming difficult for them to come to some compromise on. So last year's bill was to create a task force, and instead of coming to judiciary, it was assigned to ENT. And the feeling there was, if 29 other entities do this, why can't Maryland, and we don't need a task force? Why don't you guys just go ahead and put a bill in for policy? So he amended last year's bill. And when the committee saw it, they said, this is really a judiciary bill, we can't handle it, and told Senator Eckert, the crossfire, and I to get the relevant stakeholders together and come up with a policy for this year. And this is what we have. We've been meeting really since the spring with various sections of the bar, the Attorney General's office, realtors, insurance, folks, title insurers, the
Delegate Hill, we need you to start to
So
wrap
this
up.
is the bill. I'm done. So I'm going to let the other folks explain it to you because I'm the non-lawyer in the group.
Byron McFarland now for 2 minutes.
Good afternoon, Mr. Chairman, members of the committee. My name is Byron McFarland. I'm the Register of Wills for Howard County, and I'm here testifying in favor of this bill. I want to thank Delegate Hill for sponsoring this bill. This is a concept that is obviously not new, as Delegate Hill said. It's used in 29 other states in DC, including one other state is Virginia. So some of our geographic neighbors use this. As many of you know, the probate process is overseen by the Registers of Wills, and we're primarily concerned with probate assets, those that are titled in a decedent's name alone or with no beneficiary. While I obviously believe it's in everyone's best interest to have a last will and testament, it's actually pretty easy to dispose of most of our assets. When we think about bank accounts, mutual funds, insurance policies, all you need to do to keep them out of probate is to name a beneficiary. You can even do that now with your car in Maryland. You can go onto the MVA website and you can designate a transfer from death beneficiary to your car. Real property is one of the few assets that's not so easy to dispose of. You either need to have your home jointly titled, or as Delegate Hill said, pay an attorney to write a life estate deed or create a trust or something like that. And again, as Delegate Hill said, that creates a barrier for Marylanders at the lower end of the economic ladder who get caught up in the probate system. And sometimes it's just because of the house. For someone who has limited means, who's a widow or widower or single, or maybe the last child in a family's generation, this bill would provide a standardized, accessible, and I think pretty secure method of ensuring their property can be distributed the way they want it to go, and prevent a lot of avoidable cost and rigmarole. This would obviously have some impact on our caseload and our revenue, though I can't say how big of an impact it will be. However, speaking solely for myself, not all my colleagues agree, I have to say that. However, but speaking for myself, I think that the importance of providing this kind of simple instrument to Marylanders who can't afford more robust estate planning outweighs whatever minimal impact I think there will be. So with that, I ask for a favorable report. Thank you.
Thank you very much. We'll hear now from Tim Chance, please, for 2 minutes.
Thank you, Mr. Chairman, and distinguished members of the committee, for the opportunity to testify today. My name is Tim Chance. I am the Tangle Title Attorney at Maryland Volunteer Lawyer Service. As part of our advanced planning project and our My Home, My Deed, My Legacy project, we encounter numerous clients facing economic barriers, which makes it impossible for them to transfer property. For those following reasons, we respectfully request a favorable report on House Bill 1270. The advanced planning project is an outreach effort designed to stabilize neighborhoods and preserve family assets. As part of our My Home, My Deed, My Legacy project, MVLS provides homeowner clinics to residents to stabilize their homes through estate planning discussions. One of the main focuses for these discussions is avoiding probate. Probate can be a costly and time-consuming process. Our clients are homeowners who are facing financial hardship, and they often don't have the resources to cover these expenses. So it's imperative that they pass as many assets outside of probate as possible. MVLS provides a comprehensive estate planning approach that includes life estate deeds, which are a great tool to address the barriers that probate raises. The transfer on death deeds just offer yet an additional tool to that probate barrier. Transfer on death deeds provide a statutory form that will allow Maryland homeowners a more accessible vehicle to keep their homes in their family. At MVLS, we're committed to removing all barriers so that all Marylanders can participate in the judicial system, and transfer on death deeds would be just another tool to make that system more equitable. I just want to briefly share a client story where a transfer on death deed could have had a great impact. So Loretta lived in her home in St. Mary's County since 2011, but the property was titled solely in her husband's name, and in 2019, he passed away. So Loretta immediately opened an estate, but while going through the probate process, it was imperative that she stayed on top of her property taxes. Unfortunately, with her income, she could not afford the property taxes without the assistance of the homeowner's property tax credit. And this was before the passage of House Bill 610, so she was ineligible for the credit, solely relying on family members to help her pay that annual tax bill. She faced the very real possibility of losing her home through foreclosure. If there had been an accessible transfer or death deed, that would have allowed the property to automatically pass to her, saving her from the trauma of potentially losing her home. Unfortunately, the situation is all too common. I just want to refer you to my written testimony that highlights another client in Baltimore dealing with a similar issue. MVLS supports House Bill 1270 because it will remove a huge barrier standing in the way of Maryland families' ability to sustain home ownership. So, Mr. Chairman, members of the committee, thank you again for the opportunity to testify.
Thank you very much. Are there questions for this panel? Delegate Bartlett.
Thank you, Mr. Chair. I think this question is for either Mr. Chance. I think it's for Mr. Chance. Can you explain why a transfer on deed how it differs from a life estate and why a transfer on death is a better tool, or a different tool for different purposes. I should say that way.
So it doesn't differ much in like the end goal. Like the end goal is passing real property outside of probate. But I think where it differs and offers value to MBLS's client base in many Marylanders is just the accessibility of it. So proposed legislation would have a form deed that folks could just use to file without the assistance of an attorney. The life estate deed, we do utilize those at MPLS, but that still requires either getting an attorney through our services or hiring counsel, which may be just a barrier for too many folks, unfortunately.
Well, can you sell property if all you own is a life estate?
So there's two types of life estate deeds. There's a life estate deed with powers and a life estate deed without powers. And both of them you could sell, but if it's without powers, you just need the consent of that person you named as the heir. But if it's with powers, you maintain all powers throughout your life. So if you record a life estate deed tomorrow and you decide next week to sell the property, you're free to do that.
Are there further questions for the panel? Seeing none, thank you very much. We'll hear now for Jeffrey Thompson in opposition. Jeffrey Thompson should be let into the room and we'll hear from him for 2 minutes. Jeffrey Thompson.
My apologies, everyone. I should be there in a moment. Zoom wanted to tell me all kinds of wonderful things, and therefore I had to click through those before I could come on.
All right, well, you're here now, so 2 minutes will
I'm
be
there.
fine.
My apologies, everyone. I should be there in a moment.
You're going to need to close the YouTube link that you were using to watch the proceedings.
Done.
Okay, 2 minutes, please.
My apologies, Mr.
That's right.
Chair, Mr. Co-Chair, and members of the committee. I am Jeffrey Thompson. I am representing the Maryland Land Title Association. I'm a past president of the association. I also am an underwriting counsel for West Core Land Title Insurance Company. And my job as an underwriting counsel, whenever a title agent has a question or a concern about the insurability of property, it's my job to determine whether or not it can be insured. The transfer on death deed, I believe the question was asked, what's the difference between that and a life estate? I think I've submitted written testimony that talks about the concept of the life estate. And the reason that many other states have enacted the transfer on death deed is because their states do not recognize what Maryland has. Maryland recognizes a life estate deed with a power of alienation, which gives the individual that creates the life estate the ability to withdraw that, to mortgage the property, to do whatever they wanted without the consent of the life tenants. In that regard, we have a document that accomplishes what the transfer on death deed attempts to accomplish. The difference between the two is we have almost a century of judicial interpretation with respect to life estate deeds, whereas we do not have that with the transfer on death deeds. The purpose and intent behind the transfer on death deed is to make it easier for people to transfer property. And I think it was stated earlier, real property is generally the largest asset that an individual has. And while it is important that they be able to pass it on to their family and be able to get it to other family members, it also would happen at a time, or could very well happen at a time, when that person can be taken advantage of, when other people who are not included within the transfer on death deed contest the validity of the deed. It is a form deed. I will tell you that I review form deeds every day as part of my job, and quite often the effect of an individual attempting to use a form deed is to create a cloud on title.
Mr. Thompson, I'm going to need to begin to have you wrap up, please.
It would prevent me from insuring it, and it may allow or may cause the family that is trying to avoid the cost and expense of an attorney to have to obtain even more costs in order to clear the title. The phrase is, if it ain't broke, don't fix it. Maryland has what other people don't have, and that is a life estate with powers of alienation. So I would ask, since we already have what is there, that you return an unfavorable report.
Are there questions for the witness? All right, seeing none, we thank you very much for your testimony today, and that concludes the testimony on House Bill 1270. We're going to go now to House Bill 1385 and Delegate Shoemaker. We'll hear from Delegate Shoemaker, Kurt Erickson, and Ed Coyne. So we'll hear from those 3 minutes for Delegate Shoemaker, 2 minutes for everybody else. Go ahead.
Thank you, Mr. Chairman. Here to present on HB 1385. Of course, we'll all recall during the debate on recreational marijuana legalization last week, a fair amount of that debate centered on how we will deal with incidents of driving under the influence of drugs once legalization occurs. And I know there's a study component in the legislation that passed out of here, but we also heard statistics during the debate about exponential increases in fatalities where drivers had THC and other substances in their system in states where legalization has occurred. And since Maryland seems to be going down this path, I think we need to be prepared, and I think we ought to be proactive. So this bill says that a person may be compelled to take a blood test as required by a valid warrant. It also authorizes police officers who have had advanced roadside impaired driving enforcement training, I think the acronym is ARIDE, to direct a person to take a test for drugs or CDS content. So that's the sum and substance pretty much of what the bill does. And at this time, I will defer to my panel, Mr. Chairman.
Kurt Erickson, please. Mr. Erickson, are you here? Mr. Coyne.
Good afternoon, evening, Mr. Chair. This is and members of the committee. My name is Edward Coyne. I'm the Deputy State's Attorney for Carroll County. I'm testifying on behalf of the Carroll County State's Attorney's Office and the Maryland State's Attorney's Office Association in support of House Bill 1385 because it clarifies existing law as it relates to law enforcement officers getting warrants for a blood sample in DUI cases. It also, as Delegate Shoemaker said, allows for additional officers who have ARIDE certifications to request a blood sample from suspected drug-impaired drivers. The Fourth Amendment and case law for the Supreme Court prefer warrants to obtain evidence. However, consent is a widely accepted exception to the warrant requirement, and the implied consent law in Maryland for DUI cases involves Transportation Article 16205.1 and the Court's Article 10309. Allows the implied consent to obtain and admit chemical tests, evidence in drunk driving cases. And again, even though consent is the permissible alternative to search warrant, it should not be a limitation on law enforcement that prohibits law enforcement after, say, someone refuses the breath test to then get a search warrant from a judge to get a blood sample, for either drugs or alcohol in that person's blood to determine whether or not they're impaired by that substance. In addition, over the last several years, there's an average of about a little less than 150 fatal collisions from drunk or drug driving in Maryland. And under the current law, only a drug recognition expert, a DRE, is able to get a blood sample to determine whether or not there's drugs or illegal controlled dangerous substances in someone's blood. This bill would be a force multiplier. It would allow In Maryland, there are only 181 DREs. So you can imagine at 2 a.m, that's not a lot of numbers to call geographically from Western Maryland all the way to Eastern Shore. So this would be a force multiplier, allowing the over 1,000 officers who have A-RIDE certification. If they evaluate the suspected drug driver, they'd be asked the driver for a blood sample. Hey, will you be willing to please give us a blood sample to determine whether or not you have drugs in your system to confirm or dispel the drug driving charge? So this bill would allow for the critical objective evidence to show whether or not that suspect was driving while impaired by drugs or controlled dangerous substance. It would increase public safety and help protect the roads from drunk and drug drivers. I'd ask this committee for a favorable report for House Bill 1385. Thank you.
Kurt Erickson now for 2 minutes.
Thank you, Mr. Chairman. My name is Kurt Erickson, and I serve as president of the Maryland nonprofit Washington Regional Alcohol Program. I just wanted to add a me too to the testimony you just heard from the Maryland States Attorneys Association regarding support for House Bill 1385 and its efforts to clarify a valid warrant's role in compelling a blood alcohol concentration blood test. Sadly, nearly a third of traffic fatalities in Maryland still involve drunk drivers, according to 2020 NHTSA, National Highway Traffic Safety Administration data. And 2020 bore witness to Maryland posting a nearly 10% increase in the number of alcohol impaired traffic fatalities occurring in the state that year, according to the federal agency. I thank you in advance for your consideration of favorably reporting this legislation. Thank you.
Any questions for the panel? Questions for the panel? All right. Well, we thank you very much. Delegate Anderson, please.
Yeah, thank you, Mr. Chairman, and thank you, Delegate Shoemaker, for bringing forth this bill. My question, I guess, concerns what happens when the officer who is, I guess, the one that calls the judge and gets the okay for the blood test, and the blood test comes back, not necessarily alcohol, but the person had some point in time consumed marijuana. What does the officer do then?
Thank you, Delegate, for that good question. So I would just, as many of the people on the panel probably are familiar, that marijuana can stay in your system longer. So just the presence of marijuana would not necessarily be overwhelming, compelling evidence that the person was impaired. The state's attorney's office at that point would probably have the case for the blood, or the officer would consult with the state's attorney's office to determine whether or not we should consult with a state toxicologist or a toxicologist to determine the level of marijuana in the system is enough for impairment. In order to go forward, we'd have to look at all the other evidence, what types of performance in the field tests, and most critically, any statements. Did the person say they were high, or they say they were dizzy, or say they were tired from consuming marijuana? Obviously, other drugs, sometimes the thresholds are higher, sometimes they won't test. But I would suggest that's good evidence to determine. Sometimes it's good evidence for evidence. It's exculpatory, that it could lead to the person not being charged. Or if the person is being charged, the state would need an expert to show that the marijuana in that system was impairing, not just presence.
Now, I understand in the past, 7 or 8 years, the Carroll County Circuit Court has been involved with the arguments with regard to DREs, whether or not they can be considered experts for testimony in court. What's the status of those cases now? I haven't really been able to keep up with it, because Carroll County was the only county that had this status. Is that correct?
It was one that I was familiar with. That's where I practice. And Judge Galloway, our retired administrative judge, he's been retired for a few years, did rule in about 20 or so cases. They consolidated a bunch of cases, and his persuasive opinion was that the drug recognition experts, the drug evaluation and classification system, which the DREs operate under, was not a reliable science under the Frye-Rees standard. I'm not sure where that would stand under the Daubert standard now that the Court of Appeals has changed the standard. I'm not sure. Currently, we evaluate every case on a case-by-case basis. We still use DREs because right now the only way you get blood is to use a DRE. We still have DREs in Carroll County, but that opinion did limit our ability with some of the evidence, but we still use DREs and get as much blood as we can. But again, we only have 3 DREs in Carroll County, and you can imagine at 3, 4 in the morning, it's hard for a road officer to get a DRE to come out sometimes. because of the shift work, because they also, most DREs also have another full-time job. They're not just DREs. Usually they're patrol officers, some other capacity. So oftentimes if they're not working the same shift, it's hard to get them to come out. At least that's my experience.
All right. So who would testify in a case where marijuana is found in the person's blood? Would it be the toxicologist, you say, or is some kind of other? What other expert?
We would need some kind of expert, because a lay witness would not be able to explain the nanograms or whatever, however they quantify the blood in someone's, the marijuana in someone's blood. So we would need some kind of expert testimony. And again, the science on marijuana is somewhat confusing, because recent use might not relate or correlate to the most impairment. So I know there's been some studies. I consult with the defense attorneys as well. I have a friend on the public defender side who educates me and some national studies. So it is tricky. And my opinion is you most often need an expert to interpret the blood results, especially with marijuana.
But you've tried these cases.
Yes.
Okay. And when you say you generally need some kind of expert, you actually do need one, because the presence of marijuana alone won't give you a conviction for driving impaired or driving under the influence, right?
Correct. In order, we have to prove it beyond a reasonable doubt. So just mere usage isn't usually enough, and just presence is never enough. We need to prove it beyond a reasonable doubt. So I agree that we would need a toxicologist to prove these, or at least sometimes they wind up being a plea. If we get the toxicologist, we get the opinion, sometimes it's no longer a contested issue unless the defense has an expert that contests our expert.
Okay. Thank you so much. Thank you, Mr. Chairman.
Thank you for the questions.
Are there questions for the panel? Seeing none, we thank you very much. And that concludes the testimony on Delegate Shoemaker's bill. Thank you all very, very much. We're going now, I believe, to a bill from Delegate Acevedo. I don't see Delegate Acevedo. He is not here yet. All right, we're going to pass Delegate Acevedo. We're going to go to Delegate Valentino Smith. Delegate Valentino Smith is House Bill 967. We're going to hear from Delegate Valentino Smith, Gavin Potashnik, David Daggett, Alex Audie, Kurt Erickson.
Thanks.
Ed Coyne, yeah, and we'll hear from Ed Coyne too. So let's do that. Delegate Valentino Smith, this is a reintroduction, so 2 minutes, please.
Thank you. It's kind of a reintroduction. It's got a little bit more thrown in it. Thank you, Mr. Chairman, members of the Judiciary Committee. This bill, drunk driving, drug impaired driving, these are something that unfortunately, when I was there, we dealt with every year, and the people that come after you will be dealing with every year, given the society we live in. So this bill tries to rectify a number of inconsistencies in the sentencing and the enhancement loopholes that have, these inconsistencies really have probably reduced some of the effectiveness. And you did hear about the increasing problems that we're having on our roads. So first, the bill increases the penalties for manslaughter by vehicle or vessel from 10 years to 20 years, and homicide by vehicle or vessel under the influence of alcohol from 5 years to 10 years. It also increases the subsequent offender penalties for the same crimes to 30 years for manslaughter by vehicle and 20 years for homicide by vehicle in situations where the defendant's been previously convicted of one of the drinking and drug driving offenses. Currently, we rank 46 in the most lenient state for penalties involving drunk drivers that cause fatalities. It's time we continue to work on that. The fiscal note has a great chart in it. Second, the bill adds operating a vessel or a boat while under the influence or impaired to the list of offenses that would enhance the penalties of a conviction under the drunk driving statutes. Basically, when I was there many, many years ago, I did the subsequent penalty bill for drinking and driving, and you guys have been working on that. So in the short amount of time I have, what this means is that in the hot months of Memorial Day and 4th of July, go out and drive your boat and you're get a drinking and driving your boat conviction. And then it gets a little cold. So at Halloween, you end up in your car on pavement behind a vehicle, get impaired driving. It does not count as a subsequent offense. It should, whether you're driving a vessel on the water or on pavement, each conviction should add up to count as subsequent convictions each time that you do it, in our state and under our law. And that's what this bill tries to rectify. And then third, I'll use my notes because I'm going to run out of
Quickly, if you
Did I run-
wrap up, please.
Did I run out of time?
Yes.
Okay. Well, third, the bill would further add the offense of manslaughter by vehicle to the list of charges applicable to subsequent offender penalties. It makes no sense that a person who's convicted of killing someone by drinking and driving and being grossly negligent while doing so doesn't get a higher penalty. I'm out of time. The public defender's office is here. You opposing this? State's attorneys and public offenders' offices from all the time that I was there poke at each other about penalties.
All right.
I think intuitively, I'm here to put the panel before you to ask that you consider closing these loopholes. Thank you, Mr. Chair.
Thank you very much. Gavin Potashnik now for 1 minute, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Gavin Potashnik, Deputy State's Attorney for Harford County. We are also on behalf of the MSAA. We are in support of this bill, and I thank Delegate Valentino Smith for her advocacy in this area. This extremely simple bill kind of holds offenders accountable for some of the most terrible type of actions that people can conform that kill people, and it closes certain loopholes to make sure that people who operate any vehicle in a terrible way can be held accountable for those particular crimes. It just seems inconsistent that a person who is charged with involuntary manslaughter is subject to 10 years. And involuntary manslaughter includes any type of behavior where an accident occurs that is an involuntary action that causes the death of another human being, versus an individual who drinks maybe 3, 4, or 5 times the legal limit and then gets into a car and kills somebody, and that person's only subject to 5 years. That doesn't make sense. What also doesn't make sense is if an individual who operates a vessel while impaired gets convicted of that offense, is they're not subject to subsequent offender penalties. They go on dry land and do the exact same things. This bill closes these loopholes, holds the people accountable, and I ask this committee have a favorable result with respect to all of the different points in this bill. Thank you.
David Daggett, please, for 1 minute. I'm sorry, 1 minute.
Thank you, Mr. Chair. My name is David Daggett. I'm the traffic resource prosecutor for the state of Maryland and representing the Maryland State's Attorney Association as well. And we fail to see why impaired boating is differentiated from impaired driving. Both certainly can cause great harm and even death. We feel they should be comparable. A vehicle is described in the traffic code as any device that can transport a person. And a boat is the same way, and we all the requirements to prove impaired driving and to prove impaired boating are similar. It just doesn't make any sense that somebody could go out and drive a boat drunk, get convicted of that, and then not learn their lesson and turn around and drive a motor vehicle drunk, or vice versa. How you can then drive a car drunk, get convicted, and then not learn your lesson and go out and drive a boat drunk. So what we're simply asking is that impaired boating be added to the list of predicates to cause a subsequent offense for impaired driving and vice versa. Finally, to echo Mr. Potashnik, there's nothing more. Everybody knows the dangers of impaired driving at this point. It's not only is it dangerous in general, but it's also deadly. A lot of people, about 150.
Mr. Daggett, I'm going to need you to begin to wrap up, please.
Okay, we would based upon that, the sheer danger of impaired driving, and when you kill somebody, we think the penalty needs to be greater than just 5 years. So the Maryland State's Attorney Association would ask for a favorable report on House Bill 967. Thank you.
Alex Audie for 1 minute.
Thank you, Mr. Chair and members of the committee, for allowing me to testify today in support of House Bill 967. And thank you to Delegate Valentino Smith for sponsoring this legislation. My name is Alex Audie, and I'm the national president of Mothers Against Drunk Driving. When I was 13 years old, I was run over by a drunk boater on July 2nd of 2010. To make this story short, I was sitting across the lake on a jet ski from my mom and brother. There was a 17-foot bass boat headed towards my mom and my brother in the boat. She screamed, he banked it to the left and never straightened up. The boat hit me from the side going more than 60 miles per hour, threw me off the jet ski. The boat went up over the jet ski and landed on top of my body. I sustained many severe life-threatening and lifelong injuries from head to toe, including a traumatic brain injury, a shattered jaw, a broken neck, bilateral shattered femurs, and the loss of my right leg. The man who ran me over was several times over legal limit. 2.5 hours later, he was charged $250 and sent home with the opportunity to reoffend, which he has done many times, both on the water and on the roadway. To no fault of my own, after spending many weeks in the ICU, 6 weeks in a neck brace and months in a wheelchair, this was my new life. I've been asked a lot over the years, if I could do that night over, what would I do differently? And the answer is nothing. I didn't do anything wrong. The only thing that would have changed that crash is if he hadn't been drunk. Boating under the influence is driving under the influence. House Bill 967 allows for BUI offenses to be counted toward anyone charged with a subsequent DUI offense, and also increases penalties for certain offenses of manslaughter by vehicle or vessel, a manner of holding further accountable those who make this deadly choice to drive under the influence of alcohol or drugs. Mothers Against Drunk Driving supports this legislation, and we urge you to please advance House Bill 967. Thank you so much for the opportunity.
Kurt Erickson for 1 minute.
Thank you, Mr. Chairman. Again, my name is Kurt Erickson. I serve as president of the Maryland nonprofit Washington Regional Alcohol Program. You have my written testimony, so let me just highlight 3 succinct aspects of House Bill 967, which we support, and obviously which seeks to count boating under the influence convictions as prior DUI convictions. Number 1, in uniformly imposing sanctions for BUI and DUI, this bill strives to make clear that impaired driving on land or on water is a distinction without a difference. Both are criminal behaviors which far too often have deadly consequences. 2, according to U.S. Coast Guard figures, in fact, 2020 U.S. Coast Guard figures, alcohol use is the leading known contributing factor in fatal boating incidents. And lastly, number 3, sadly, and according to 2020 National Traffic Safety Administration data, nearly a third of traffic fatalities in Maryland still involve drunk drivers. Worse, 2020 bore witness to Maryland posting a nearly 10% increase in the number of alcohol impaired traffic fatalities occurring in the state last year. As a means of equitably applying the state's DUI and BUI laws, I thank you in advance for your consideration of favorably reporting this potentially life-saving legislation. Thank you.
Thank you. Ed Coyne, please, for 1 minute.
Thank you, Mr. Chairman. Edward Coyne, again, Carroll County State Attorney's Office. I'm the deputy. I joined Maryland State Attorneys Association. The Carroll County State Attorney's Office supports of House Bill 967. It's an effective means to hold DUI offenders who cause death accountable for their actions. I concur and ditto what's been said by the panel. I would just add that it also gives judges more flexibility in sentencing. It allows the judges to hold additional period of incarceration over the head of the offender and place them on probation, because I'm sure the panel knows that DUI, homicide, manslaughter are considered nonviolent offenses under the Correctional Services article. Offenders are eligible for parole at 25%. So you can imagine a DUI homicide offender getting parole in about a year and a third or a year and a fourth, about 15 months, they're eligible for parole on a 5-year offense. And this would allow a judge, instead of 5 years, having 10 years. If they gave him 10 years, spent about 5, the person could serve an offense and then be on probation with additional time hanging over their head, kind of a stick or a carrot hanging over the person's head to make sure they comply with the laws during the period of probation, to make sure that they toe the line, stop drinking, and get into a program. So I support and ask for a favorable report of House Bill 967.
Thank you. We'll take questions now. Delegate Cardin, please.
Thank you very much, Mr. Chair. Just real quick, thank you for bringing this bill. I know we've dealt with it before. Let me just make sure I understand. I don't know who the right person is. Maybe Mr. Potashnik, maybe Mr. Coyne. If you have a young man who is convicted of a DWI at, say, 18 or 19, and he doesn't have any other problems, let's say 5 years later, he then gets into an accident and kills somebody. That person could potentially be exposed to 30 years versus somebody who's an involuntary manslaughter offender who would only be exposed to a maximum of 10 years. Is that my understanding on this bill?
So someone with a prior for manslaughter, we currently would expose to 15, but yes, we would increase that to 30. And my understanding is someone for the DUI homicide would expand it to 20 instead of 10. So someone with a prior DUI that's convicted of these crimes would face a more substantial penalty. And this would increase the penalties that are currently established, because if someone has a prior, it is taken into consideration.
Thank you.
Delegate Anderson.
Yeah, thanks, Mr. Chairman. I'm going to pick on Mr. Coyne again because I've got a question related to, we're talking about driving on land and driving in the sea. I took flight lessons out at the air park in Carroll County many, many years ago. And I was just wondering if you knew of, or have you heard of, people being arrested for flying under the influence, flying airplanes under the influence out of that air park, or what happens if that happens?
Thank you for the question, Delegate Anderson. I have never had, I've been with the office 20 and 1/2 years, and I've never had a DUI or someone flying while impaired. I think the Federal Aviation Administration covers that. I'm not sure.
Okay.
A different capacity. When I graduated college, I worked for a federal court, and I remember hearing about someone being prosecuted for a flying while intoxicated, and their standards, instead of an 08, I think they're really low. You can't have any alcohol in your system. So, but again, I don't have any experience prosecuting any pilots for flying while intoxicated, but I think I've heard that the FAA handles that, but I'm not sure. I can't answer.
Delegate Anderson, if I may cut in, yes, the FAA handles it. Also, if you look at the DUI legislation, DUI bill, subsequent offenders of any federal offense would count as a subsequent offender penalty.
Is that current law, or is that in this bill?
No, that's current law.
Okay, perfect. All right. And Mr. Coyne, yeah, you've been in 20 years. Yeah. Now I remember who you are. Okay.
Yeah, we've had cases.
We have had cases. Thank you.
If I could address Delegate Cardin's question real quick, chances are in your scenario, sir, that 18-year-old probably would have gotten a probation before judgment, and probation before judgment would not count as a second offender in this situation. So PBJ does not count.
Except that because he was 18, the judge didn't afford him the PBJ and gave him the conviction, maybe no jail time, but gave him the conviction.
In that scenario, yes, you are correct. But almost everybody gets a PBJ unless they hurt somebody.
All right. Are there any further questions for this panel? Seeing none, we thank you all very much. I understand that Crystal Williams, who was to testify for the Office of the Public Defender, is not with us. So we're going to move on. That concludes the testimony for House Bill 967. We thank you all very much. We're going to go now to Ms. Delegate Acevedo here. Delegate Acevedo is here. That's fine. So we'll hear from him now for House Bill 463. This is a previously introduced bill. We'll hear from Delegate Acevedo for 2 minutes. And then there is one witness to testify in opposition for 1 minute. So Delegate Acevedo, please, for 2 minutes on House Bill 463.
Thank you, Mr. Chair. House Bill 463, in essence, end qualified immunity for law enforcement officers in state court. For the benefit of the committee, qualified immunity is a judge-made legal doctrine that shields law enforcement from civil liability when they break the law, which in effect allows police officers who engage in police brutality to do so without repercussions and without the threat of personal liability to strain their actions. Officers can use excessive force fearlessly. Simply put, qualified immunity is antithetical to accountability. When passed, House Bill 463, among other things, will end the defense of qualified immunity in state court for law enforcement officers, and ensuring that those who engage in reckless behavior and display a wanton disregard for human life can be held personally accountable for their misdeeds and answerable to the communities. Now, I know that there are some opponents who argue that ending the practice of qualified immunity would lead to an increase of lawsuits being filed against police. And I'm just here to say that such fears are not only exaggerated, what we're seeing across the country, rather, is the public being left holding the bag. And so House Bill 463 provides that where a court determines that the police officers But House Bill 463 not only ends a qualified immunity as a defense, it would ensure that level of accountability that really represents the unfinished work of police reform that we did last session. I believe we should join our counterparts in Colorado, New Mexico, and California in ending this legal doctrine that not only has no statutory basis, it denies victims of police brutality as well as their families due process in court. I will also just add very quickly, and this is something that came out today by the Washington Post, and encourage folks to take a look at it, that in essence showed that the Post uncovered thousands of police officers who alleged repeated misconduct cost taxpayers over $1.5 billion. And so we have to send a clear message. Ending qualified immunity, in essence, says sends that clear message, and I urge a favorable report from the committee.
Thank you very much. Are there questions for Delegate Acevedo? Seeing no questions for Delegate Acevedo, we thank you very much. And we'll now hear from the one witness in opposition, Mike Davey, please, for 1 minute. If we could let Mr. Davey in for 1 minute, please. Mr. Davey, please, for 1 minute.
Thank you. Good afternoon, Chairman and members of the House of Delegates. My name is Michael Davey. I am the General Counsel to the Maryland State Fraternal Order of Police, and we oppose House Bill 463. It's a fix to a problem that doesn't need to be fixed, and there will be unintended consequences as a result of this legislation. We don't dispute that citizens should have the right and to be able to sue for violations of their constitutional rights. Under current Maryland law, they can do that now. In addition to claims of assault, battery, false arrest, false imprisonment, malicious prosecution, Marylanders can also file constitutional state claims under Articles 24 and 26 of the Maryland Declaration of Rights. Plaintiffs' attorneys have and continue to do just that successfully without any issues. Law enforcement officers are public officials acting under the scope and the duties of color of law. As a result, all torts against them outside of car accidents would be negligence acts, but also have potential constitutional claims. Just one example would be if an officer makes an arrest and it's found that the officer arrest was not supported by probable cause, not only would he or she be in violation of a possible tort for false arrest, but also state constitutional violations. Under current law, plaintiffs are allowed to sue and do sue for constitutional violations. Maryland law does not allow for qualified immunity defenses or good faith defenses in those cases. Obviously, this is a very big issue for the state FOP. Where again, the police officers are being treated much differently than any other public official, and for that reason, we would oppose the passage of this bill.
Are there any questions for Mr. Davey? Seeing none, that concludes the testimony for House Bill 463. Thank you very much.
Thank you.
We're going to move now to Delegate Cox and House Bill 859. We'll hear from Delegate Cox. He's the sole person to testify. Delegate Cox, go ahead on House Bill 859, please, for 3 minutes.
Thank you, Mr. Chairman, members of the committee. As we know, the United States was created from the individual states uniting together to form a larger governing unit for the benefit of the whole. The individual states did not come together to give up their independence or their ability to govern their own affairs. If they had, we wouldn't have 50 states with 50 legislatures. We would have one state and one legislature, which would make all the law. But in fact, the 10th Amendment of the Constitution specifically states that the powers not delegated to the United States by the Constitution nor prohibited to it by the states are reserved to the states respectively or to the people. This means that anything that is not an express power given to the United States government, specifically in the US Constitution, is a power that remains with each state and the people of those states. Article 3 of the Maryland Declaration of Rights repeats the delegation of powers under the 10th Amendment, that those powers not specifically given to the federal government are the state's powers. Article 4 of the Declaration of Rights in Maryland doubles down on that principle saying, quote, that the people of this state have the sole and exclusive right of regulating the internal government and the police thereof as a free, sovereign, and independent state. House Bill 859 reinforces that right and stands up to the continued overreach of power by federal government into the rightful realm of this state. Nothing in the Constitution gives the federal government any power to make laws regarding the ownership or use of firearms. That is the power which is reserved to the individual states and the people of the state. And in this state, that would be a power reserved to the Maryland General Assembly. As the Firearm Protection Act states, quote, the right to be free from the commandeering hand of the federal government was most notably recognized by the United States Supreme Court in Prince versus United States, 521 U.S. 898, 1997, where the court held that, quote, the federal government may neither issue directives requiring the states to address particular problems, nor command state officers or those of their political subdivisions to administer or enforce a federal regulatory program. We've even had debate in this committee before on other topics of issue regarding this involvement. And so in that same light of principle, if the U.S. Constitution and Bill of Rights, the Maryland Declaration of Rights are to be upheld, are to be upheld, House Bill 859 should be passed. It merely directs a unit of state government and the federal government that they may not violate or aid in the violations of Marylanders' rights under the Second Amendment. It also gives Marylanders residents recourse to sue for damages if their rights are violated, and government employees who participate in that violation can be held liable. If any government employee violates an American citizen's most basic right, the right to keep and bear arms, they're liable. 16 states have some similar type of protection from federal government overreach under the Second Amendment. More than 61% of all counties nationwide have ordinances, laws, or resolutions which outright state protection under the Second Amendment right of its residents. Article 19 of the Maryland Declaration of Rights in our Constitution incorporates part of the Magna Carta and states that, quote, every man for any injury done to him in his person or property ought to have remedy by the course of the law of the land and ought to have justice and right freely without sale, fully without any denial, and speedily without delay, according to the law of the land. House Bill 859 fulfills this mandate of Article 19 by allowing Maryland residents legal recourse. I thank you for the opportunity and ask the Honorable Committee to move favorably on House Bill 859.
Are there any questions for Delegate Cox? Any questions for Delegate Cox? Seeing none, we thank you very much. And that concludes the testimony for House Bill 859. The Vice Chair is going to take over, starting here with Delegate Beitzel's bill, but let's get all the witnesses in. So we'll hear from Delegate Beitzel for 2 minutes. This is a reintroduction for 2 minutes. Katie Novotny, Mark Pennack, John Jocelyn, Michael Burke, Nicholas Ditello. We'll take them all as one big panel. And so thank you all very much for that. And so I'll pass it to the Vice Chair, but let's go to Delegate Beitzel, please, for 2 minutes. Who has to unmute himself?
Thought it was off. Can you hear me?
That's better. Try it.
All right. Thank you. Good afternoon, Chair Clippinger and Vice Chair Moon and members of the committee. For the record, I am Delegate Beitzel, and I'm here to present House Bill 1132, the Gun Theft Felony Act of 2022. Currently, stealing guns is treated the same as stealing a watch or a wallet. The penalty is based on the value of the stolen property. This means that anything under $1,500 is considered a misdemeanor. Stolen firearms, especially handguns, are almost always valued at less than $1,500 and treated as a misdemeanor offense. These offenses are often dismissed through plea bargains deals. We also know that stolen firearms are frequently used to commit crimes and can be commonly found on the black market. I think even President Biden in his State of the Union mentioned that the two police officers that were killed in New York were killed by a stolen firearm. Finally, Maryland law already prevents felony offenders from purchasing or owning a firearm, but not for misdemeanors. This bill is very simple. It would classify the theft of a firearm as a distinct felony offense. This will increase deterrence and make sure that the crime is treated like the serious matter it is. It would also prevent offenders from trying to get a gun after their sentence. The bill strikes a balance of addressing one component of illegal firearm possession while not infringing on the rights of lawful gun owners. It would align Maryland law with almost every other state in the country, including neighboring and progressive states that also classify stealing a firearm as a felony. Our state has a high rate of violent crime, and our body must take action. There was no mandatory minimums imposed in this legislation, and I'm happy to discuss anyone's concerns. I genuinely believe this bill should have bipartisan support, and it will protect the lives and property of Marylanders. Thank you for your time, and I urge a favorable report on this bill.
All right, thank you very much. Now we'll have 1 minute from Katie Novotny.
Good afternoon, Chair and members of the committee. My name is Katie Novotny. I'm coming to you from District 35B. So thank you, Delegate Beitzel, for bringing this this bill forward. So, we regularly have seen, and you guys voted today in the full House, for more very strict penalties on firearms owners. And there's a lot of violent crime in this state, committed with handguns. And I think it's time that we put real teeth behind penalties for stealing, a handgun. No one steals a handgun for any use, that's legitimate. So I appreciate that, the effort's been made to remove mandatory minimums from this, because I understand that, those have been a concern in the past. But raising this offense to the level of a felony does make a person who steals a handgun a prohibited person for future purchases. So I request a favorable report. Thank you.
Thank you very much. Now we'll hear from Mark Pennock for 1 minute.
Thank you, Mr. Vice Chair. Mark Pennock, I'm the president of Maryland Shall Issue. I'll be very brief. Stolen guns are crime guns. They're immediately sold and then resold, and resold are virtually untraceable past the first legitimate purchaser. So the reality is that these guns are used in violent crime all the time in Maryland. There's a massive stolen gun problem in Maryland. And yet there is no penalty for stealing firearms of any appreciable amount. It is absurd to allow someone who steals a firearm, who's convicted of this offense, and still be able to purchase a firearm, because the offense is not disqualifying. At a very minimum, the state should make this a misdemeanor punishable by more than 2 years, so as to attach a disqualifying amount to the offense. And that will ensure that at least that the thief will not be able to purchase it. I would add to Mr. Novotny's point is this body, the General Assembly, just voted on second reading to punish an innocent homemaker of his own firearm with 3 years of imprisonment if he fails to serialize his homemade gun by January 1, 2023. And yet this body has permitted a thief who knows that stealing is wrong to get by with no punishment at all. We urge a favorable report on this bill. Thank you.
All right, looks like John Jocelyn is not here with us, so we'll go to Michael Burke for 1 minute.
Thank you, Mr. Vice Chairman. Michael Burke, District 46. I join Mr. Pennock in his comments. Theft of firearms is the primary source for handguns and other weapons used in crimes of violence against persons in Baltimore City and across the state, as well as across the country. Yet, there is no meaningful penalty for someone caught in the act of, again, stealing a rifle, pistol, shotgun. This statute is well called for. If you're going to consider possessing a homemade firearm to be a serious crime, shouldn't stealing it, breaking in someone's house, car, or other facility, stealing firearms should rise to a more serious level of punishment than merely possessing a homemade firearm. I urge an unfavorable report. Thank you.
All right, and next we will hear from Nicholas Titello for 1 minute.
First of all, thank you, Vice Chair and committee for your time and listening to us. I know it's probably been a long day for you. I'm an independent voter from District 5. I came here to just tell you that I think this bill's good. It's one of the few bills that I'll come and actually support on this panel, because unlike these other bills that we've talked about that will hurt law-abiding citizens or just straight up citizens for common activities such as building a firearm or in past years transferring a firearm privately. We see large punishments for things like that, but when we have an actual known issue with theft, where people are getting killed and hurt by stolen firearms, that's, I think, where this panel could shine and actually make Maryland a better place to live. Because right now, I mean, it's the same punishment as if I stole a TV. It's based on the cost of the material good being stolen. It's not based on the fact that you're going to probably kill someone with that firearm you stole. A lot of these guns have obliterated serial numbers, unlike personally homemade firearms that someone like I might make. A stolen gun will likely have its serial number obliterated before it's just sent on to the next person. It's a loophole in the current law that needs to be closed. We talk all the time about compromises in networks. And to close up, I think that this is that compromise. This is where we need to actually make change in favor of punishing criminals over law-abiding citizens. Thank you, and please vote favorably on this bill.
All right, and we have one question from Delegate McComas, please.
Thank you, Mr. Chair. This is for Mr. Pinnock or any of the other folks that might be able to answer it. But when you were talking about the firearms being stolen, and of course we've had a lot of testimony today about firearms, whether they're engraved and everything. Do you know of the firearms that are stolen and then they get, and they're seen in crimes? Are the serial numbers crossed out on those firearms, if you know?
Yes, they often are. The Baltimore Police Department released information recently that shows that a good number of these recovered firearms have their numbers obliterated. That is already a crime under federal law and state law. So it's not like it stops them, but that means it will be more difficult to trace. Now, there's good technology for raising the serial number that the police departments do use, but obliteration is common.
Okay, thank you.
And if I may add, I myself had a firearm stolen from my house when someone broke open a safe and stole a revolver that was legally possessed and registered by Maryland State Police. That was in 1993. I'm still waiting for the police to locate it and return it back to me. It had a serial number. It was registered. It was lawfully owned and legally locked up in a theft-resistant safe. There's no penalty for the person who committed that crime. They'll probably never get caught. This is a bill that makes sense. There should be teeth in a statute that penalizes someone for that kind of violation.
Thank you.
All right, next we have a question from Delegate Faye Martin Howell.
Good afternoon, Delegate Beitzel. I just want to thank you for bringing this bill, but I have a question for you. If the serial number is not on the gun, how do you determine that it was stolen? And the other question is, how do you determine if a gun is stolen if it's not reported by the owner?
Well, if I may, Doug, how people that lawfully own firearms, and if you purchase firearms from reputable dealers or through Walmart or any of the gun dealers that have licensed firearm are licensed firearm dealers, those guns are all have serial numbers on them. People that own guns legally have guns with the serial numbers on them. The guns that are stolen from, like if they would steal them from me or some other sportsman or from anybody that purchased those firearms from like Remington or Weatherby or one of those guns that, you know, sportsmen purchase or someone who buys a handgun, that gun has a serial number on it because it comes from a manufacturer that keeps serial numbers on those guns when they manufacture them. So, and then when you purchase any guns today, you have to, when you buy it, they have a record of the gun and it has a serial number on it. So guns that are stolen, usually, I mean, almost in every case that I would know would have a serial number on it. But once the people that steal them get them, then they can take the serial number off. And then it would be harder to trace where it came from. And it would be harder to trace if they stole a gun from me or anyone else, if they took the serial number off where it came from. But in the case of just, I mentioned before, like the President Biden had said in his State of the State, that there's 2 troopers that were shot in New York, had a stolen handgun and that killed those troopers. So it probably had a serial number on it, but it would, and somebody else may have some thoughts on this, but the police, I mean, the people that buy the handguns can take that number off, and it would be harder to trace it to where it came from.
Okay.
If I may answer, Mr. Vice Chairman?
Yeah, briefly, go ahead.
When a handgun, regular firearm, is purchased in the state of Maryland since the 70s, the state police require that transaction be recorded on a Form 77R, which is then kept in a database at state police headquarters. And when you sign that 77R applying for the transfer, you agree to report the weapon, if it's stolen, within 72 hours to the police agency having jurisdiction. A police report is taken. Maryland State Police has the serial number on record, so that can be added to the report. The report is then entered into both the state database for stolen firearms and the FBI's NCIC, the National Criminal Information Center. So stolen firearms are recorded and tracked by state and federal law enforcement agencies. If and when one is recovered, it can be identified back to the owner and back to the time and place where it was reported stolen. So that chain of evidence is there. That's what makes a registered firearm theoretically traceable. Unfortunately, yes, a criminal could attempt to eradicate such a serial number, but the nature of the serialization process used according to ATF regulations makes it extremely difficult to completely obliterate that engraving. In reality, both the Maryland State Police Crime Lab, several county crime labs, and the FBI and ATF crime labs have the capability through microscopic examination can go into and check the area where the serial number was, and often using advanced techniques, recover that serial number despite whatever means was used to attempt to obliterate it. So again, that number can be recovered and again, tracked back to the original owner and the original report of theft, if that helps.
Okay, thank you.
If I may, I have just a very brief thing to add, Mr. Chair.
Yeah, briefly.
Okay, so I'd like to add that, we need to make sure that we're keeping, whether something's serialized, it's a separate issue, in my opinion, from whether it's stolen. But to speak to, how you can track it. So even outside of the Maryland State Police records, as a firearm owner, my husband and I have extensive firearms collection of, some valuable items. So So we personally also have a record of all serial numbers of all firearms we own and a brief description, and our firearms are insured. So we have, extra records for that. And I know that, we are not unique, in that situation. So I'd like to add that. Thank you.
Delegate Cardin.
Thank you, Mr. Chair. Just very quickly, in the debate earlier today, I believe that this bill was very similar to an amendment that was proposed and eloquently responded to by the floor leader. But it was brought up that these types of offenses do not go unpunished. In fact, there's the possession of a stolen or a possession of an illegal or a firearm without the rightful having all the rightful papers and everything is a significant crime with significant potential penalties. So I think that's covered, and so I don't think it's fair to say that there's no crime in stealing a firearm. And then the other question is, do you know, Delegate Beitzel, whether there's been any studies as to how many lost firearms are lost versus stolen, and whether there's any indication that things are reported stolen when they're actually lost?
I don't have those numbers. Maybe somebody that's testifying for the bill may have that. But Delegate Buckle, when he testified on an amendment on this, listed the numbers of stolen firearms in several states and had those numbers. So, we can get you those numbers, of the numbers of firearms that have been stolen, especially in Maryland. So, but the problem is, if it's a stolen firearm and it's less than $1,500, even if they use the firearm to commit some other felony, they can plea bargain down, and then they get charged with a misdemeanor. Then that doesn't prohibit them from then purchasing firearms or possessing firearms, and they can continue to purchase firearms, and that's really one of the main reasons for the bill. So to make stealing a gun a felony rather than a misdemeanor.
May I address real quickly the first question?
Go ahead.
Very quickly, the first question, the first statement regarding that Delegate Cardin made regarding the enforcement of the enforcement that's already put on people that have stolen a firearm. It's not necessarily true that the person who stole a firearm, it is known that they have the improper paperwork, because between the fact that it was only until 1968 that firearms started getting serial numbers, there was only, I forgot what year it was, where Maryland started actually tracking and carrying about the 77R. There's also ways to build a firearm at home, and there's also the fact that rifles, only until this last year, could be privately sold. So there's no 100% guarantee that somebody that's stolen a firearm will actually get a number of charges equivalent to more than whatever the minimum is.
And Vice Chair, may I add a legal point to this?
Very briefly.
Yes, I watched the debate today on the floor. Delegate Lopez cited to section 5-144 of the public safety article. It is she cited that as opposing a 5-year penalty, and it does, but only for knowing violations of subtitle 1 of title 5. And the text of section 5-144 only applies to regulated firearms, and a regulated firearm does not include a long gun. And I don't find anywhere in subtitle 1 anything having to do with the sale, possession of a stolen firearm. So I think the misunderstanding here is that there is existing law that would be violated by possession of a stolen firearm is simply incorrect, at least under section 5-144. Thank you.
All right. It looks like that's going to conclude the hearing on House Bill 1132. We are now going to go to House Bill 871.
Mr.
If,
Chairman.
yes.
Thank you, Mr. Chairman.
Wonderful. Thank you. All right, so if Delegate Saab is here, we'll go to 871 next. Let me just, there he is. All right, and we've got 5 witnesses signed up on this bill: Katie Novotny, Mark Penek, John Jocelyn, Michael Burke, and Nicholas Ditello. This will be 2 minutes for Delegate Saab and 1 minute for the witnesses. So Delegate Saab, 2 minutes when you're ready.
Thank you, Mr. Chairman, and good afternoon, Mr. Chairman and members of the Judiciary Committee. For the record, I am Delegate Sid Saab, bringing before you today House Bill 871. This is probably one of the most exciting bills you're going to hear today, hopefully, and it's because it's a common sense bill, and it brings, it's also a simple bill, rather. So what this bill does, it deals with the application for concealed carry. So what this bill does, it allows the state police to issue a preliminary approval for handgun carry applicants before the applicant has to go through the other requirements. So current law says in order to get concealed carry, you have to do the following things. You have to send the application, you have to take the 16-hour class, which you will get educated on Maryland gun laws, the surrounding state laws, and show proficiency. And then you have to provide a good and substantial reason to carry. You have to pay the fee, and then you have to submit the fingerprints and then wait. So this takes time, effort, and money. So what this bill intends to do is to have the state issue a preliminary approval before the applicant has to go through the class and pay the fee, and in the end get denied. So if you fit the criteria, and the state police gives you the thumbs up and say, okay, you're good to go, you can move forward with the application. And at this point, you would have to take the class and do everything else you would have done before. You still have to take the fingerprints and make sure you submit them 72 hours prior to submittal of the fee or the application. So if you don't meet the criteria, then it's over. It's that simple. The applicant didn't waste any time, money, and the state didn't waste time and money either. Very simple. It's completely a common sense bill. The cross file is Senate Bill 338, and this session it passed unanimously across the street on the Senate side, and it will be making its way over to the House next week. And with that, Mr. Chairman, member of the committee, I request a favorable report on House Bill 871. Thank you very much.
Thank you. Next, we'll have Katie Novotny for 1 minute.
Good afternoon, Chair, members of the committee. Thank you, Delegate Saab, for bringing this important bill. I think this is common sense. And sorry, for the record, Katie Novotny, 35B. We've seen this bill before, and I know there's a letter out there from the Attorney General urging you guys to vote against this. And that letter erroneously states that that's going to allow people to carry firearms prior to the training. And that is simply not true. This bill just allows you to find out if you're going to be approved for a permit prior to spending the time and money on your training. And excuse me, I'm in the process right now of applying for the permit, and I've spent a significant amount of time and money. I had to take time off work to get the fingerprints done, a lot of things. And I, don't know if I'm going to be approved. And this is something that Marylanders go through on a regular basis. And this is just some very common sense legislation that just streamlines this process. So I urge a favorable report. Thank you.
All right, next we'll have Mark Penek for 1 minute.
Thank you, Mr. Vice Chair. Mark Penek, President of Maryland Show Issue. This bill passed unanimously in the Senate last year. It has passed unanimously in the Senate this year. It passed this body, this committee, in 2020. You have my written testimony that identifies bills and the dates. It has only died in 2020 because time ran out and sine die. So there is really no substantive objection to this bill. No one has said that people should be forced to spend hundreds of dollars on training before they're applying. So the bill just makes common sense and is good government. We urge a favorable report.
Next, we'll have, I believe John Jocelyn is still not here, correct? All right, let's go to Michael Burke for 1 minute.
Thank you, Mr. Vice Chairman. Michael Burke, District 46, urging a favorable report for this legislation. I'm also a firearms instructor and an advocate, also many years in law enforcement and the military. This is a common sense bill. It can, as has been previously testified, cost well up to $1,000 or more to go through the process from zero to getting a handgun permit issued. The uncertainty of spending that amount of money for something that may or may not be granted is an onerous condition for what is essentially a human right. We're asking that you, again, favorably pass this bill, because that way applicants, citizens of your jurisdictions can apply for a permit, have their background check done, have their preliminary approval granted by the state police, and then go seek the required training to move forward with their application. Thank you for your time.
Thank you. Next, we'll have Nicholas Ditello for 1 minute.
Thanks again for having me, Vice Chair. I just wanted to point out here that this bill is good. It breaks what, in my mind, is a very classist, very targeted bill, existing set of laws that targets those that are less fortunate. I, as a software developer over years, have built up enough time and money, and have a little bit of a background of some privilege to where I could very well go through the entire process of training, fingerprints, photographs, fees, all of that, all the time, all the money, all of that, then just to be denied. That in itself is a problem. But think about your constituents who are often in neighborhoods or situations where they don't have the same levels of privilege that I do. They don't have the same level of either money or time to be able to do that. So all that we're asking is to just give preliminary approval so that all of these people, myself included, just know ahead of time that we can get this training done and all those other steps to then get the permit. No other neighboring state has this requirement, and the current system is pay to play. Again, I think this will take down overreach from law enforcement that is desperately needed. And more importantly, I urge you to vote favorably on this bill.
All right. Thank you very much. Are there any questions for this panel? I've got just one quick one on this one. Maybe this is for Mr. Panak or Ms. Novotny, since they would have been here for some of these other debates. But would it be fair to frame this bill also as a preliminary rejection? Isn't that sort of the same thing this bill is getting at? I had often wondered if this terminology was one of the reasons we were getting hung up on what was going on in the bill.
Yeah.
Absolutely. So you at least have the certainty at that point, knowing that you've been rejected without spending hundreds of dollars on a training course that may be even difficult to obtain in the first place. So you could either call it preliminary approval or you can call it preliminary rejection, but the result is the same.
I concur with Mr. Pennock. It should actually be called a preliminary consideration, because no citizen knows whether they will be approved or denied. There are people who get denied handgun permits and HQLs for offenses they didn't know were on their record. There are people who can be denied for a number of circumstances under the Gun Control Act of 1968 and existing state law. So people find out and get preliminary disapproval notices for issues they did not know they had. And this saves those people who end up going to us and to other attorneys saying, can I fight this? Like, no, the record is clear. You're not statutorily eligible. This kind of bill especially helps minorities who might otherwise have spent $500 to $1,000 for training and application fees to only be denied something that should have been caught earlier before they, again, spent all that time and money, especially city residents who can't do the training in their own city.
Yes, and to add, it's the good and substantial reason is somewhat, it's very vague. And, there's some classes such as, business owners, realtors generally get approved, people with the TS clearance that have been, affected by the OPM breach. Some of those people, it's pretty clear that they're likely to be approved. But it's all those people in the middle that maybe, they think they have a reason, but, there's no black and white answer. And so absolutely for those people to, find out that they have been disapproved prior to spending that time and money.
Yeah, I phrase it just sort of as a marketing question, given where this debate is. So, all right, well, that's all. And it looks like there aren't other questions. So thank you very much. That's gonna conclude the, thank you.
Thank you, Mr. Chairman. If you have a better idea to help the passage, if you want to change the title, I'd be happy to accept your amendment.
Above my pay grade, but we'll talk, I'm sure.
Thank you. I appreciate it. Thank you, Mr. Chairman.
Thank you. All right. Well, that's going to conclude the hearing on House Bill 871. We're going to go to a pair of bills. No, one bill from Delegate Kipke, if he's here. Yep, he's here. And we've got 5 witnesses on this one. Katie Novotny, Michael Burke, John Jocelyn, Nicholas Tatello, and we have a favorable with amendment from Evelyn Burton. So why don't we get started with Delegate Kipke when you're ready.
Thank you, Mr. Chairman and members of committee. It's great to be with you. House Bill 1174 would modernize Maryland's law as it relates to the issuance of carry permits. Currently, Maryland has a status known as may issue. This would change Maryland's status to shall issue. I think this is important because right now, the people who can get a permit in Maryland are the elite, the affluent, the connected, and even the wealthy. For example, think of this: landlords who collect rent, pawn shop owners, tattoo shop owners, bail bondsmen, bar owners, and generally any business owner, florists, grocers, landscapers, etc. As long as you own a business, you can pretty much get a permit as long as you're lawfully able to possess a firearm. Also, physicians, lawyers, politicians, and judges are among others, such as retired law enforcement, who are also eligible. However, law-abiding Marylanders who don't own a business, aren't elected or any of these special positions, can't get one. Why should someone with identical backgrounds accept one pays rent instead of collecting it or prevent it from accessing what I believe is their civil right? Does this sound equitable to you? Maryland sticks out in a tiny little grouping of states. This map that I show you here, the green represents the places in America that have a law for shall issue. The tiny little grouping of states that are red are the places in America that have a may issue. Even New Jersey has a less restrictive law than Maryland. So the fact that we are unconstantly restricting this in a way that, in my opinion, infringes upon people's civil rights, and there's no gain, there's no reduction in crime, in my opinion, it's just wrong. It is a fact that statistically, concealed carry permit holders are the least likely population to ever commit a crime. Think to yourself, would you be uncomfortable to walk in a grocery store or walk down a street and pass by somebody with a carry permit that's carrying concealed? The fact of the matter is you probably have on a regular basis, because about 6% of Marylanders have a concealed carry permit and self-attest that they carry on a regular basis in public? Have you visited Richmond, Philadelphia, Washington, D.C. lately? They all have shall issue laws. The people there have carry permits. And the difference is we discriminate against law-abiding citizens who aren't in a special class. Yes, the state of Maryland and this legislature is complicit in denying this civil right. Some say turning Maryland into a shall issue state will bring the wild, wild west to Maryland. This mindset denies reality, facts, and all nationwide statistics. On the other hand, where we see violent crimes committed with firearms, reminiscent of the movies or Hollywood's Wild, Wild West, it is nearly entirely committed in the hands of someone using a stolen firearm, with the serial numbers scratched out, by the way, without a handgun qualification license, without a legal background check and transfer. They are also likely already committed a felony or other crime that makes it the possession of a firearm illegal. The bottom line is the people we fear do not respect our laws and do not and will never take any of them, will not take the time to apply for a carry permit. I understand that some are uncomfortable when it comes to firearms and the idea of citizens with carry permits. However, those who have discomfort and hesitancy need to know the following. The data shows that there's no increased risk to public safety, and arguments can be made that where there are more carry permits issued, it serves as a deterrent to crime. The data shows that permit holders are among the very least to commit even minor crimes. There is no excuse to discriminate between citizens in such an inequitable way. And finally, continuing to not deny this civil right to Marylanders is wrong, discriminative, and unconstitutional. I urge the committee to finally reject this archaic policy and pass House Bill 1174. Thank you.
Thank you very much. Next, we'll hear from Katie Novotny.
Good afternoon again, Chair and members of the committee. Katie Novotny from District 35B. Thank you, Delegate Kipke, for bringing this bill. This is a common sense bill, and I'd like to add I love your map. Has may issue and shall issue, but I'd like to add that Northern California acts as essentially as may issue. They're done by county, so actually much of even California behaves as shall issue. So I'm going to refer you to my written testimony. I have links to a lot of the information that Delegate Kipke actually, talked about. Some of these studies saying, how law-abiding carry permit holders are. So, it's just not a problem. And, this bill would eliminate the different classes of people created, under this system. And, there's large groups of people that don't have access to the training and whatever, and they choose for self-defense reasons only. They're not committing a crime other than carrying a firearm without a license. They choose to carry because they live in areas that are not safe. And, then unfortunately, these people sometimes get caught, and now they have a criminal record. They've done nothing else wrong besides try to have a means to defend themselves. And, reversing this, making this much easier for people to lawfully get a carry permit will go a long way in eliminating that issue. And also, the New York State Rifle Pistol Association versus Bruin case is set to be decided by the Supreme Court. That was argued November 3rd, and we expect a decision by the end of June. It is likely that they will strike down New York's good reason clause, which is identical to Maryland's good and substantial reason clause. So even if this bill does not pass, the good and substantial is on limited time. I request a favorable report. Thank you.
Thank you very much. Next, we'll hear from Michael Burke.
Thank you, Mr. Vice Chairman, members of the committee. Michael Burke, District 46. I'm a little out of turn, but I don't mind. I would rely on the written testimony of Mr. Pennock, MSI's president, for most of the legal points and statistics that support the arguments raised by Delegate Kipke. I thank him for his excellent presentation, which stole half of my talking points. But I'd remind you that if you look at, again, Mr. Pennock's written testimony, Even Johns Hopkins has conducted a study which found that concealed carry by people who are lawfully permitted is not a threat to public safety. In fact, it improves public safety across all the other states that have permissive allowance of humans to carry firearms in their own self-defense have less crime than we have in many parts of our own state. I urge a favorable report and recall that the majority of people who are denied permits from the state police are minorities, because that's who the law was written to disenfranchise back in the dark days of 1968, 1972, when these statutes were originally drafted. So I urge the favorable report and consider giving the state police the authority to issue a permit based on self-defense. Thank you.
All right, next we're going to hear from Nicholas Tatello.
Thanks again, Vice Chair. With this bill in particular, self-defense. We like I believe Katie was saying, we have separate classes of people right now, because one person, here's the big thing, is one person can put self-defense down and another person could put self-defense down. And it's entirely possible that the law enforcement officer who's reviewing person one's application might deem it qualified and person two's unqualified. That's entirely up to human error and also human judgment, which, as we know, could imply abuses of police power. I think that this bill makes it to where that we have even ground to where people know that self-defense, when they submit it, is a valid reason, and they don't have to waste their money, time, effort, which many of us don't have, to apply for this and still get told no. Right now, a lot of people, when they apply with self-defense, it's thrown in the trash. I believe that this bill will hold police accountable for the current skewed balance of what it does and doesn't get through the application process. And for those reasons, I urge you to vote favorably on this bill. Thank you.
All right, we have one question from Delegate McComas.
Thank you, Mr. Chair. And this is for anybody that could answer it. I was wondering, because that map was so green that Delegate Kipke showed, I was wondering if there's any type of correlation or linkage that the states that have shall issue, if they have a much lower and significant murder rate and gun violence as compared to, let's say, Maryland, which has, it's very difficult to get the right to carry.
So in my testimony, I have, it lists Maine, Vermont, New Hampshire as the 3 safest states. And those are actually all constitutional carry states as well. So they go even further than shall issue. And I've got some links to some other crime data, but yeah, it's, there's no, there's certainly no increase in crime or violence when states go to shall issue.
There, you mean a decrease?
Sorry.
Yeah, that's what
a long day. I've been watching you guys all day too. Yeah, crime does not increase when states go to shall issue.
Because is it because the criminals like to pick on people that it's kind of a sure thing that they can pick on?
I'd say yes. I'd say absolutely. Not knowing if that person is armed, to me, would certainly be a deterrent, and thinking twice about, attacking a person.
But if you know in your kind of a no crime, no gun zone, and you're a bad guy, you're going to feel pretty confident.
Yeah. And, we've seen, there's been studies that, going even further, gun-free zones are, one of the main places that people love to attack, because they know for certain, everybody that, is following the law doesn't have a firearm there, even further than no carry permits. So yeah, it's definitely a deterrent to crime. Is it 100% effective? Not necessarily, but, we see defensive firearm uses frequently, and these are often not reported. It may be, you're not rise to the level of someone actually calling the police to report that they used a firearm defensively, because there may have been no shots fired. It may simply, someone, stop, I have a firearm, and the person, stops the attack. So that, absolutely is a deterrent.
Thank you.
And if I may, Delegate Vice Chairman.
Yeah, sure, briefly.
I've been in law enforcement for over 30 years. And yes, I've been studying the question of violent crime, armed robbery, rape, murder, attempted homicide, all usually using firearms. The rate of incidents tends to be higher in cities and populations where permits are not issued. New York City, Detroit, LA, Baltimore are cities where the majority of the population are known to be unarmed, or if they are carrying handguns, they're only carrying them illegally. Allowing a more liberal use of the term self-defense to allow people to defend themselves is most likely going to reduce violent crime, because, as Delegate McCombs has asked, criminals are less likely to attack someone who's going to fight back. Thank you.
All right, and that looks like it's going to conclude the hearing on House Bill 1174. Oh, we got a hand up from.
Did we lose Mark Pennock?
To address you, Vice Chairman, I just really quickly wanted to say I did apply for the next bill, cannabis and right to possess, own, and carry. Unfortunately, only my written testimony got through. So I'll just leave it at that then, as I did want to testify. But
Sorry, unfortunately we can't add you, but I got you. We're registering you as a +1 on that bill.
Thank you.
Yep. Okay. So we are concluding the testimony on House Bill 1174. We are now going to skip over to a pair of bills from Delegate Grammer, starting with 482 and then 1206. 482 is a reintroduction, so 2 minutes for Delegate Grammer, and we've got 2 witnesses signed up, Katie Novotny and Mark Pennock. We'll each have a minute. So Delegate Grammer, you have 2 minutes when you're ready.
Thank you, Mr. Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 42. House Bill 42 protects the firearm ownership rights of those who qualify to use medical cannabis and limits access to the databases of qualifying patients. This issue arose after the legalization of medical cannabis in Maryland. Relevant qualifying forms inquire to a person's status as a qualifying patient. If you answer that question yes, you lose your rights to own or carry a firearm. Combat veteran Josh O'Neill testified in 2019 that he carries a firearm as part of his employment and would like to use cannabis for pain management due to a combat-related injury. Ironically, he works for the medical cannabis industry. He described his addiction to pain pills for 2 years and his recovery. I'm in horrible pain every day. I sleep about 2.5 hours every night. I just want to sleep. What does it say when we force those who served our country in combat to choose between employment and non-addictive medical solutions or perjury? The commercial growth, distribution, and sale of cannabis in Maryland violates federal law. We sanction a federally illegal industry, but treat qualifying patients as second-class citizens. We should protect their rights of firearm ownership by passing House Bill 482. With that, I'd be happy to take questions, and I'd ask for a favorable report.
All right, next we've got Katie Novotny for 1 minute.
Good afternoon, Chair, members of the committee. Katie Novotny, District 35B. So, I support this bill, but I would suggest one amendment, and that would be that the effective date would be when when federal law removes marijuana from a Schedule I drug. There's a number of issues right now. The whole reason for this bill, there's some issues between, federal law and state law with this. And unfortunately, I don't think we can ignore some of those federal laws. I think there's some stuff that we'd get into, but I love the idea of this because I don't think people that use this for medicinal purposes should lose their Second Amendment rights. I don't think they should lose any rights for using this. It's certainly much safer than, many opiates and stuff. I remember the testimony from that gentleman from 2019, and it was quite moving. But I think we need to be ahead of this. And if we, pass this, but have it take effect when that's removed from Schedule I, we wouldn't have to play catch up after the fact. So thank you.
All right. And do we have Mark Penick here? Yes.
Yes, Mr. Vice Chair, thank you. I'm enormously sympathetic to the purposes of this bill, and I very much appreciate the bill being brought. I have submitted informational only testimony on the legal framework associated with the illegalization of marijuana in Maryland and in the federal government. Right, and that details all the legal risks associated with the use of medical marijuana by under federal law associated. So I'm cautious about this because if the bill passes and someone applies for an HQL and they actually get an HQL and they go to a federal firearms licensee to purchase a firearm, that FFL is absolutely required by the ATF to deny that purchase. It's right on Form 4473. It's an attachment to my written testimony. You can look at it yourself. It's question 11 at the bottom. So that would mean that that person who spent the time and money to get the training, spent the fees to get the HQL, is basically wasting his time and money without necessarily knowing this. And that would be a travesty. I would support any sort of legislation that would encourage the federal government to change Schedule I. And if it was up to me, I would change it tomorrow. It's facially absurd to have a prescribed opiate be fine and prescribed marijuana not be fine. So with that, I would urge a favorable report with the caveat that it's going to be very difficult to actually enforce this against federal law. Thank you.
All right. Are there any questions for the sponsor or these witnesses? Okay, that's going to end the hearing on House Bill 482. And now we're going to go to House Bill 1206, which is, I believe, the final bill of the night. And for everyone else's benefit, we've got a voting session 30 minutes after these hearings end. But Delegate Grammer, House Bill 1206, we have 4 witnesses signed up, Katie Novotny, Michael Burke, and Nicholas Tatello favorable, and Mark Penick is a favorable with amendment, but we'll call the 4 of them up. And Delegate Grammer, you have 3 minutes when you're ready.
Thank you, Mr. Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 1206, Maryland Constitutional Carry Act. House Bill 1206 strikes the permitting requirement to carry a firearm for lawful owners. Most laws restricting firearms have racist roots. This is specifically true for laws regarding the carry of firearms. Minorities, specifically women and Black Americans, are currently the demographic groups where gun ownership and use is most quickly growing. Following this trend, many states are adopting constitutional carry laws. Indiana is the latest state which passed constitutional carry this week as the 22nd state passing the law. The majority of states actually have laws allowing for the carry of a handgun without a license. Not only does requiring a license hurt those who are poor, but it puts average people through a politically driven adjudication process which removes or delays the right of self-defense of potential victims. But it does nothing to stop criminals because they are already determined to break the law. Criminals don't wait for a license to commit crimes. However, many places in the state, such as Eastern Baltimore County, are experiencing real increases in violent crimes, such as carjackings, and are seeing an increase in gang activity. States that pass constitutional carry typically see reductions of violent crimes and even petty crimes within 5 years. The details of local criminal violations clearly demonstrate that those with ill intentions will blatantly disregard laws related to the purchase, transportation, sale, ownership, possession, use, and sale of firearms. We should ensure that law-abiding folks are equipped to defend themselves, because it is clear that those seeking to harm others will disregard any restrictions. We can do that by passing House Bill 1206, Constitutional Carry Act. With that, I'd be happy to take questions, and I'd ask for a favorable.
All right, now we have Katie Novotny for 2 minutes.
Good afternoon, Chair, members of the committee. Thank you, Delegate Grammer, for bringing this fantastic bill. For the record, Katie Novotny from District 35B. So I'm happy to say that my written testimony as submitted is now outdated, because I had listed, as of when I wrote it, there was 21 states. So the addition of Indiana is exciting, and I need to update that now. So as I mentioned in answering a question from one of these other bills, currently Maine, Vermont, and New Hampshire are rated as 3 safest states, and they all have constitutional carry. So, we've seen articles and all kinds of things that people choose to carry regardless of the law, depending on their circumstances. People that live in dangerous areas carry. Currently, unless you are a business owner or hold a TS or something like that, you do not have the right to self-defense outside the home in this state. That's just a fact. I certainly cannot fend off someone with a firearm, who's a prohibited person. I'm not a large human. I just can't do that. The state may or may not deem me worthy of carrying a firearm, but this bill making it, legal for all lawful firearms owners, those who are not prohibited, to carry, without having to go through these expensive, time-consuming, hoops to jump through, will go a long ways in, reducing some of this violent crime, because armed people don't make good targets. And when someone doesn't know if someone's armed or not and thinks, this person might fight back, they are less likely to attack them. So I request a favorable report on this. Thank you very much.
All right, I'm back again. Thank you very much to the Vice Chair. I believe Michael Burke is next for 2 minutes.
Thank you, Mr. Chairman. Michael Burke, District 46, rising in support of Delegate Grammer's most excellent proposal. I urge a favorable report. We need to come into the 21st century, as testified by Ms. Novotny and others, and do away with some of the onerous provisions of law that have been designed to disarm Blacks and other minorities, dating all the way back to the first permit scheme passed by this General Assembly in 1715, which prohibited Blacks from carrying a firearm without permission from their master or owner. There's no reason that we should be requiring a permit for someone to exercise the free right of self-defense. We don't require a permit authorized by the state police to vote. We don't require a permit from the state police in order to operate as a priest or other clergyman, or a permit to perhaps practice journalism. None of that requires a good and substantial reason to exercise human rights, otherwise protected by our state and U.S. constitutions. Again, thank you for your time, and I urge a favorable report.
Nicholas Tatello, please, for 2 minutes.
Thank you, Chairman. So with this bill, I believe it's an excellent opportunity for this panel to make progress towards equity for the citizens in Maryland. Right now, as the law stands, only the police end up being the ones with guns, and I don't like that. we need to have it to where there's not two classes of people, those that are armed and those that legally have to go through a million jumps to actually be able to also be armed. So the armed and the unarmed. I believe the current status quo is hurting the less privileged the most. They're the most impacted, especially low income, high population, high density population areas with families that just can't afford to go through the current process. The current level of gun control that we have going on in this country, it targets minorities. It enables the police state to arrest and jail citizens. And I mean, we've seen it like in New York, for example, with stop and frisk. We've seen where the police state is just allowed to target people over whether they're carrying or not carrying a gun. And we know where that leads. We know that people that are not so privileged are normally in the crosshairs. I myself, I don't really come from, I come from a position I feel of privilege, but I've got multiple members of my family that are LGBT and also are either working or sometimes even living in areas where they don't feel safe. So with that, I very, very much urge a favorable report on this bill, as it will help set with the problem we have with separating people in classes.
Mark Pennock, please, for 2 minutes.
Thank you, Mr. Chairman. Mark Pennock, President, Maryland Show Issue. I joined in Delegate Grammer's remarks, and he's absolutely correct. And you'll find in my written testimony on this that there's now statistical studies concerning the impact of constitutional carry laws, which have blossomed in states surrounding us. The indication is that this actually leads to a statistically significant decrease in murders in these states. And there is no statistically significant increase in these states. In other words, the fear that there will be blood in the streets because people are carrying simply doesn't pan out. And that is because guns don't cause crime, people cause crime. And these people who carry, or otherwise law-abiding, are simply not causing the crimes. They are able to prove to improve their odds of self-defense, and the statistical data on that is conclusive that armed self-defense is the most effective way for providing for self-defense. And again, this happens between 500 to 1,000 to 3 million times a year that people use firearms for self-defense. Doesn't mean they're shooting them, it just means that they're effective in keeping themselves from being victims. I urge strongly a favorable report. Thank you.
Questions for the panel. Delegate Lopez.
Thank you, Mr. Chair. There's no question that many of our laws and even our firearm laws in the state and across the country have racist origins, right? It's a part of like systemic structural racism. So I'm wondering, with that in mind, and the testimony that we've heard today, if there is a need from people of these marginalized groups to benefit from this bill, why don't you have any representatives of those communities testifying?
I would like to respond to that, Delegate. I recently gave a talk to the 10th Cavalry. It's a gun club that's part of the AGC, Associated Gun Clubs of Baltimore. And I asked them specifically, and the 10th Cavalry, in case you don't know, is a all-Black group that was assumes the name of the 10th Cavalry that was used during the Civil War. And they're all avid firearms users and all completely lawful users. And I asked them to come and testify. And they looked at me, and then one guy stood up and he said, I'm not going there and putting my head above the crowd, because there's a history of retaliation against members of the Black community, and they're not taking chances. So no, you're not going to hear very much from the Black community because they are afraid of being retaliated against. Whether you think that rational or otherwise, it is a reality.
And I'll also make a brief comment. So I talk very frequently about Duncan Lemp and what happened down in Montgomery County. The impetus of that case was that he shared a Facebook post of him posing with a rifle. That rifle, the picture of him with the rifle, was then used to someone who he was former friends with and had a beef made allegations about him, and that led to the investigation of what allegedly was an illegal ownership of that firearm, and people claimed that he had owned a firearm that was on the do not own list. Now that, as we know, looking back, that was that was not found to be the case. But in communities of gun owners, you know, it's commonly said and it's commonly shared, do not show pictures of yourself on social media with a firearm, because frankly, it's a liability. And there are a lot of, you know, people scanning and phishing for pictures that can be used to damage you. You know, and I don't think it's good practice anyway, but that's frankly, I think, how most gun owners feel, is anytime you come in front of a public forum, you're going to be oppressed. And I think a lot, not only do a lot of the criminal cases, you know, are a fairly good reason to understand why, but a lot of the legislation here, I think people just feel a bit oppressed. And I will say that I don't frequently search for supporters, frankly, for most of my bills, unless they're technical. I like people to come from the community, but I think in general, gun owners are very reluctant to come to a public forum and say, you know, I own guns, I'm supportive this or that law.
Mr. Chair, Delegate Lopez, I'd like to respond in part.
Go ahead.
I invited and information on how to testify before this panel to several of our MSI members who are African American and other minorities. Most of them stated they could not because they had a day job and were not available to break away from their bread and butter at 1 o'clock, 1:30 in the afternoon to come testify in the middle of the day. The fact that, again, the mere technical challenges with coming in the middle of a day for a hearing, even though we end up doing this at 7 o'clock at night, prevents a lot of people from stepping forward to offer their testimony. Fact of life.
And
Mr. Botany.
thank you. So, you know, I'm a regular here. It was terrifying when I first started, you know, and I live in an area that, you know, I don't, you know, have the same fear, you know, that some others do. I don't look like some others, but it is still terrifying when I decided that I was going to be an advocate and put my, you know, it's published on the website, my name, phone number, address, all that stuff when I submit written testimony. You know, that's a really scary thing to do, particularly when you are, you know, this isn't a bill that's going to criminalize anybody. But, you know, in general, a lot of people don't get involved because they don't want to out themselves as someone who has a thing that's going to be banned or participates in an activity that's going to be outlawed. You know, it's scary to put yourself out there in that way. And, you know, marginalized communities have faced things that I've certainly never had to face. And, you know, if it's scary for me, I can only imagine how scary it is for them. And, you know, it's hard to, you know, commit to take off work. You know, I took off 9 hours today to be here, and turns out I could have gone to work. So, you know, there's so many factors that play into this. And I don't really think it's fair to say because there are no, you know, minorities present that they don't support, you know, legislation like this.
Further questions for the panel? Seeing none, thank you very much. That concludes the testimony for House Bill 1206 and concludes the testimony for the bills today. Committee, we are going to come back now and vote at 7:30. We were going to try for 7:15, couldn't quite make it. So we will be back here at 7:30. Thank you all very much. And we will see you in about a little more than a half hour. Thank you.